And they say that Leader McConnell is a very good vote counter.
Yes, hello, welcome everyone. Welcome to yet another edition of Uncivil Law. We are here with the ongoing impeachment inquiry, madness, whatever this is. Fun times had by all is what it is.
Not a fair trial.
Nothing short.
I hope that he's wrong, because whatever
and we are
here.
This just started about
pledged or
20 minutes ago.
Has been superseded by an event.
So Adam Schiff has just been talking a little bit now about how it's all horrible.
An oath.
So for those of you who may not remember how this works procedurally,
not to your legislative leadership,
the House designated
the
prosecutors, which they're called managers, and so he is one of the members of the House who is over in the Senate explaining to them why Donald Trump should be impeached and all the rest of it.
Many of you in the Senate,
and one of the reasons we're covering it is because Chief Justice Roberts is presiding. So is this Supreme Court react? Is this SCOTUS react? I don't know. But we're going to watch this and comment to some of this garbage fire for a little bit. I don't know how much of this we're going to actually wind up covering, but we'll cover some of it.
And that oath requires
we got the closed caption on so you can all enjoy this. This is, of course, this feed is courtesy of C-SPAN.
To the American people.
So this is U.S. government created content, which means that it is copyright free. Yay. So we can use it all. Ewan, you don't have to delete messages. It is a garbage fire. Good times. Yeah. So I'll be here with your legal garbage and fire. Garbage and fire. Fair enough, Ewan. Your correction is duly noted.
Party of the president was.
Yeah. Good times.
Would it make sense to you to have the trial first and then decide on witnesses and evidence later? Would that be fair?
Oh, my friends, we are here together with the wonders that is the impeachment of Donald Trump.
Let me be blunt.
Donald John Trump. Oh, and I should clarify that. The first impeachment of Donald Trump.
A great many, perhaps.
There's no way this is the end of it, right?
Believe there will be a fair trial. They don't believe that the Senate will be impartial.
As opposed to the House, which was super impartial, right?
The president will be acquitted. Not because he is innocent. He is not. But because the senators will vote by party. And
yay, impeachment. Well, yay, impeachment or no.
From coming out.
It's what's happening now.
To make sure the public never sees it.
Riley. Hello, Riley.
The American people want a fair trial. They want to believe their system of.
I figure we'll cover this for maybe an hour or two, maybe three, and
they want to believe that we can rise
see what
happens and
happens.
Do its best for the country, but a great many Americans don't believe that will happen.
So this is the first day of the impeachment trial. The Chief Justice swore everyone in, and Schiff is the first person to be talking. He's been talking for, I don't know, 10, 15 minutes or something.
Not by conviction
so
alone,
you have not missed much. Not that you need to watch anything, because you will not miss anything at all. I mean, I can tell you exactly what's going to happen, and so can anyone else with half a brain.
By letting the House call witnesses, by letting the House obtain documents.
William Blair says, can he appeal? No, he cannot appeal. This is a political process, not a legal process. There is no appeal from the Senate's judgment. So if the Senate convicts, that is the end of it. There is no appeal.
Now let's turn
they are
the
group of first and last resort when it comes to this issue. Because it's not political, it's not legal, it's political. That, despite the fact that Chief Justice Roberts himself is in the room right now as presiding officer. So we have a judge, in fact, the Chief Justice presiding, so it looks legal, but it's not. And I mean that by not to say it's not lawful. It is lawful. When I say it's not legal, I mean it's not a legal process. It's a political process. So, no, there is no appeal from this. Not that it matters either way, because we all know exactly how this vote is coming out to this.
The parties and the American people.
Hey, Newt, how you doing?
According to the resolution the leader has introduced, first, the Senate receives briefs and filings from the parties.
Oh, yeah. So I don't know if anyone saw that tweet from Legal Eagle yesterday, everyone's other favorite legal commentator, he was saying how he was sad that he had to print out the 150 pages of garbage that was the Donald Trump legal response. I'm like, well, Devin, that's real open-minded of you there, characterizing it as garbage before you read it, I'm sure. It's like, well, we know where your opinion is on this thing. Jeez.
So to say, let's just have
I'm hunting around for another lawyer to do a live stream with. If Leonard wants a piece of this, then we'll talk to Leonard. But I was hunting around to see if Data Viva or someone wanted to cover some of the 100 whatever pages of Trump's response. I thought that might be fun.
Senators, and then and only then, after essentially the trial is over, after the briefs have been filed, after the arguments have been made, after
the Dems really screwed this up too, and Matthew was commenting on this too, as a law student. He was pointing out, like, you know, that a 1L with a bucket of mud and a stick could have written a better indictment than what the House did, because it's just so floaty and so abstract. That the Trump's legal response of none of this is actually a crime is actually not too bad. Like, yeah, well, that's a pretty good response. And the Dems just couldn't be bothered to wait for the court decisions on whether or not, like, certain people would be forced to testify or whatever. So, good times.
In this scheme, and saw it for what it was. Yet there is still more evidence.
I'm sure it is garbage, but then when you're replying to the garbage, does that make me a garbage man? Garbage men get paid well. Do I get union time for this?
And those around
him. Yeah. Someone should just raise a motion to take a quick vote. I'm sure someone thought about it. But we got to do the kabuki. We got to do the kabuki. We got to have witnesses. I don't know what the deal is on witnesses yet, if they've discussed that or what's going on.
As John Bolton has offered to testify in the
a soft sit could have done it better. Ewan, you probably are not wrong. A soft sit might have been able to do it better. Yeah, this is not in lines with the free bad, COD fact, and all the stuff. Would have been just about as coherent. Yeah.
As documents released under the Freedom of Information Act have documented the alarm at the Department of
Oh, I also saw this really interesting. Where did I see it? Was it a tweet or an article or a headline or something? I forget exactly what the context was. But it was some left-wing media group, and they were saying Donald Trump picked his defense attorneys for this based on who would make the best presentation on TV. Like this was some sort of scandal. That was the headline. Like Donald Trump picks legal talent based on who will be best presenting on TV. Like that's an invalid consideration for a client. Like who's going to be a good person to communicate to the public, particularly in this context when it's political, not legal. So the ability of the legal mind is perhaps less important than the ability of the person who is good on TV to present it. So that's probably a dominant consideration, I would imagine, in this context. Also, the people we picked are like not fools either. And, you know, Ken Starr, of course, from the Clinton trial, and Dershowitz, and all those wonderful people. I mean, they're talented lawyers. Yeah. Lobbies YouTube to get you a pay raise. Well, someone bloody random as always. I do accept super chats, so if you want to give me a pay raise, just saying, it's available. But of course, I'm just happy to have you here either way. Yeah, the stream has just been open about 10 minutes. Just been open, and we missed about 10 minutes worth of intro before the stream started. So I will just tell you what happened in the 10 minutes that started. Okay, he's been speaking this whole time. So this is the first guy to be speaking. John Roberts is there, Chief Justice of the United States. He could be in the Supreme Court, you know, deciding actual legal issues, but no, he's doing this instead. So that's annoying. And Adam Schiff is, of course, a member of the House. He's the House Intelligence Committee chair, and he is one of the managers, what you would also know as a prosecutor. And he is presenting, I guess, what we would call an opening statement, except it is like not what a lawyer would call an opening statement, because unlike an opening statement in trial where it's like, here's the evidence you will hear about, here's the specific evidence, because you see, a real lawyer by the time they've started the trial, here's something. A real lawyer, by the time they start the trial, all the evidence has been collected. They know the witnesses that are going to testify. They know what they're going to testify to. They know what the evidence is. They know what it's going to show. So they can say things like, ladies and gentlemen of the jury, we're here to discuss the case of whatever. You will hear from witness A, who will testify to this. You will hear to witness B, who will testify from this. You will hear from witness C, who will testify for this. At the end of this case, you'll be asked to render a judgment as to defendant's guilt, and I am confident that you will return a verdict of guilty. Thank you. That's your template for an opening statement for a prosecutor. And then the defense attorney's template is, ladies and gentlemen of the jury, you have heard from the prosecutor about the evidence they want you to discuss, but what they didn't want to tell you about was the evidence that exonerates for my client. For example, you will hear from witness E or witness D, who will testify about this. You'll hear from witness E, who will testify about this. You'll hear from witness F, who will testify about this. And at the end of this, I am confident that you will render a just and true verdict that the defendant is not guilty of the crime charged. Thank you. There's your template on how to do an opening statement 101, right? But of course they can't do that because they don't have any evidence and they don't have any witnesses and they don't know who's being called. So it's like, well, we're just going to give a really persuasive sounding speech about how the Senate needs to be objective and rise to the duty, and I don't even know. This is just all kinds of whatever. In the course of the House impeachment proceedings. Yeah. He threatens to invoke one now in a last-ditch effort to keep the rest of the truth. Yeah, that your jury, that your lawyer is relatable to the jury is not an invalid consideration, right? You don't just want a sharp legal mind. You want someone who's also going to be able to communicate well to the jury, someone who's going to be able to come off well, someone who has presentation skills. Which is not the same thing as being a good legal researcher, not the same thing as being a good academic. The person who's really good at trial may not necessarily be good at other things, and vice versa. That's why we have multiple fields, right? So, like, you're hiring your lawyer based at least in part on how they're going to come off to the jury is kind of an important consideration, yes. You don't necessarily want the sharpest legal mind. You want someone who's going to present well to the jury for your case. You want someone preferably who is going to sympathize or be sympathetic to the same pool that the victim is going to. So, like, if you're on trial for something and there's a victim, then, then all else being equal, you want a lawyer who most represents the victim, right? Because then it's like they can speak from a place of authenticity as they're speaking for your innocence, or at least as a factor you can consider. Obviously, there's other ways it can go, but picking someone who looks like the victim, who is in the same class as the victim, gives that person some authority to speak and say why you should not be held guilty, so they can be a good representative for that. So as a defense lawyer, that's one thing you look at. Yeah. Are we talking about why they need 24 hours of opening statements? Because they have no actual facts? They have no actual witnesses? They have no actual case of any description that I would recognize? I say this in every possible sense. They have no legal case. I mean that not just in the sense of it being political. I mean in the sense of they didn't charge a crime. Will you let him? None of this is anything a lawyer can analyze, because they're crimes that they're making up on the fly. With the U.S. Code, as big as it is, and as much stuff as there is in the Code of Federal Regulations, and there's that book that says, called 3 Felonies a Day, which, as the name implies, suggests that every American is guilty of 3 felonies a day, because of the major overlapping federal statutes, federal regulations, state statutes, state regulations, locality regulations, so forth and so on, that it's just impossible to not be in constant violation of the law. He ordered the executive branch to defy Yet, even though Donald Trump has been president for 3 years, they couldn't find anything to charge him with that was a violation of the law. Okay, that makes sense. The same counsel that stood before you a moment ago to defend the president's misconduct. He then affirmed it again at a rally on October 10. Following President Trump's categorical order, we never received key documents and communications. It is important to note, in refusing to respond to Congress, the president did not make any
any formal claim of privilege ever. Instead, Mr. Cipollone's letter stated, in effect,
do you think they should have pissed an existing federal crime? Yeah, I think they should have. I think they should have charged at least one actual crime, along with, because every other impeachment that's ever occurred, and I mean that for not only presidents but also like anyone else who's ever been impeached. All the impeachments that have ever occurred up to this point have included some criminal charge. Now, at least in some of those cases, some of those criminal charges were kind of questionable at best. For example, when Andrew Johnson was impeached, he was impeached over the Tenure in Office Act, which at least was a law. It was probably unconstitutional, but it was a law that existed, so they could say, well, he violated this section of the law, even though the law itself was probably unconstitutional. But here it's like, not charging him with anything. That's a crime. If you think he's guilty of obstruction of justice, there's a criminal section that defines that. If you think he's guilty of, various things, there are sections that define that. You could say, well, this is a violation of, just start at 18 USC section 1 and just keep going until you reach something that reads on it. I'm sure you'll find something eventually. Yeah, they didn't even try. They didn't even try.
File written by career professionals as they saw the president's scheme unfold in real time.
Okay, so now they're arguing obstruction of Congress. Okay, so they're arguing obstruction of Congress. Let me tell you what they're arguing, and let me tell you why it's crap. They're arguing obstruction of Congress because President Trump, in response to requests from Congress for certain documents or certain witnesses or whatever, said no, don't cooperate, don't do it. Now, he's the chief executive, right? So all the people that work for him have to follow his directions. And he's like, don't give him any documents. And then the Congress went to court, which incidentally, like that court case is still ongoing, last I checked, in the D.C. District Court of Appeals. I think they had a hearing on it on the 13th. And that case is still ongoing as to whether or not, what was it? I can't remember off the top of my head who it was supposed to testify and the case was about, but it doesn't matter, right? So rather than like wait for that court process to be done, and rather than wait for the judge to say whether or not they would have to cooperate or not, then they just went forward. And this is not unprecedented. I don't care what Adam Schiff says. Every president, to some degree or another, has refused various requests from Congress to turn over certain documents. Now, Schiff is trying to argue it's different because Trump is not turning over anything. He's not turning over anything. Now, to me as a lawyer, that doesn't really fly as an argument, because if you have a valid subpoena against you and you refuse to turn over nothing versus you refuse to turn over everything but one document, you're still going to have problems with contempt of court. So like, it doesn't become like less illegal to not only turn over some things. So presumably, if it's illegal for Trump to refuse to turn over anything, or everything, it's illegal for him to refuse to turn over anything, in which case you have to implicitly indict every president basically ever, because they all have done this. The executive and legislative branches fighting each other on Congress wanting stuff and the executive not wanting to give it to them is nothing new. See, for example, or if we put that in legal parlance, CF, the Fast and Furious scandal.
Indeed, in the case of Don McGahn, the president's lawyer who was ordered to fire the special
Hello, Liberty Cause. Glad to have you here as always. Nice for you to be here. I'm glad to have you as a supporter of the channel. Thank you for being here. Mr. Revalian, good to have you. The obligation to cooperate with Congress, that's what courts are for. The executive branch and the legislative branch are not playing nice with each other. So what you do to solve this problem is you go to court and have the court figure it out. And that process is still ongoing. Now, they could have waited. They could have waited for it and then say, they're not only in contempt of Congress, they're in contempt of court for refusing to obey a court order, which incidentally, by the way, is a criminal charge. It's defined in the code, so you can charge them with that. So there's all that stuff.
But it's quite another when the president is the cause of his own complaint.
Yeah, Jake the Hammer says, just file crime a day until something comes up that fits. Yeah, I'm sure crime a day has many suggestions. For example, they were throwing around the term bribery for a while. Well, bribery does actually have an actual definition in the actual federal code. They could have theoretically impeached on bribery. They didn't impeach on bribery. So presumably, they don't think that they have a case for bribery. The fact that you didn't charge any criminal case, so you don't think you have a case. It's like, well, okay.
On receiving all of the evidence so you can render impartial justice and can earn the confidence of the public.
Does anyone know how much time he was given to allowed to talk?
Fair trial. Under the
I feel like this is already too long for an opening statement. This is just a personal opinion, though.
On impeachments. It does not just debate them. Instead,
we're 30 minutes into this. That's, I mean,
all cases
that's kind of long for an opening statement. An opening statement really should be a tease. Now, that being said, that's a personal opinion. There are a lot of lawyers who use a lot of time for opening and closing statements, but for me, opening statement is get in, get out. You know, it's a tease. You know, I don't. It's not supposed. In my view, it's not supposed to be long. Get in, get out. Get to like actual stuff.
The Constitution that speaks
it's just meant to frame the case. You know, my witnesses are going to carry it for me. I don't need a lot of.
It requires them to
you know, I don't need a lot to insert a lot in the opening.
Innocence or guilt.
You know, I just need to create a frame so that there's some understanding. But how long is he allowed to talk? A. Hedinger says 24 hours per side. Really? You were really serious about that when you said that 24 hours per side of opening statements?
Full Senate trials in the history of this republic, including those for Presidents Andrew Johnson and Bill Clinton. Indeed, in President Andrew Johnson's Senate impeachment trial, the House managers were permitted to begin.
I'm telling you, if I'm a U.S. Senator right about now, am I allowed to bring a laptop on the floor? I don't think I am. Or did they change that rule? I can't remember. They used to not allow laptops on the floor of the Senate. You have to remember the Senate is very traditional. I think until like very recently they still had quill pens and stuff. So I'm not sure you're allowed to bring like laptops on the floor of the Senate. But I'd be like surfing the internet and doing Amazon purchases right about now.
In most trials, this body has heard from many witnesses.
Yeah.
Ranging from 3 in President Clinton's case.
Have they guaranteed any witnesses yet? To my knowledge, I don't know what the deal on witnesses is. I don't know what the deal is there. I think it was Adam Schiff who was saying, well, we shouldn't have to negotiate over witnesses, and was also saying, well, the Republicans shouldn't be allowed to call Hunter Biden. It's like, well, you know, or was that Nadler? One of them. Either way, it's like, yeah.
Supports it. To start, consider Leader McConnell's own description of
the GAO opinion is one thing, but how much weight that should be given is like dubious at best. So it's like Judge Claiborne's trial. He looks like a happy guy.
In the same essay, Leader McConnell recognized
he looks like a happy, smiling guy.
The body's responsibility for amassing and digesting evidence.
Wonder if he was convicted or not.
For the Senate to amass and digest in that proceeding.
Jake the Hammer says, I wonder if Chief Justice Roberts is just following Robert's Rules of Order. Ha, 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 ha. Your joke is appreciated. Not that it matters, but no, he's following the Senate rules, but I understood the joke. Very good.
At no point did the Senate limit evidence to what was before the House. It did the opposite, consistent with unbroken Senate practice in every
I'm not streaming this for 24 hours. I'm telling you right now, I'm not streaming this for 24 hours. I'm streaming this for maybe an hour or two, and then I'm giving up. But I figured we'd get at least some of it in for a lawyer react, and see who wants to join us for lawyer reacts to impeachment proceedings. Judge Portorius, 2010. I don't know anything about Judge Portorius. I don't even know who that is. 2010. Maybe we should look him up. Portorius. Portorius. Portorius.
Before the House.
Yeah.
There are many other examples of this point, including the Senate's most recent impeachment trial.
Good times.
Porteous in 2010. It is one that many of you and some of us know well. It too is consistent with this long-standing practice. There, the Senate heard testimony from 26 witnesses.
Adam Schiff looks like such a...
before the House during its impeachment. In full.
What's the most polite word I can end that sentence with?
Of the Senate hearing from new witnesses
of
impeachment.
Putz? Let's go with that.
There has never been a rule limiting witnesses to those who appeared in the
How's
House
this even relevant? Don't ask questions like that, Mr. Rebellion. If you ask questions like that, you're going to go crazy.
And that is because, as Senator Hiram Johnson explained in 1934, the integrity of Senate impeachment trials depend heavily upon the witnesses.
Oh, well, that is relevant because he's like, well, basically, it's like, look in the past at all these other Senate trials we've done and how many witnesses and how many documents have been added. So shouldn't we have witnesses and shouldn't we have documents in this trial too?
I would argue in the case
I don't know. It's a little off point because, like,
any conceivable doubt
here's your predicate. Predicate is persons being charged with murder. Question: how many witnesses are going to be called? I don't know. I have no clue. One, maybe, for all I know. It could be. Probably not for a murder case, but you get my point, right? Like, they're just because, like, there's a case ongoing, like, it's like, oh, in all these other murder cases, we had all these other number of witnesses. Therefore, we should have this many witnesses in this murder case, too. It's like, well, I don't know. We need as many as we need. How many do we need? Maybe we need one. I don't know. Could be.
For example, Rule 6 says the Senate shall have the power to compel the attendance of witnesses and enforce obedience.
McConnell calls for 24 hours to be divided over 3 days rather than 2. Who's proposing 2 12-hour days? Who can keep conscious that long?
Materiality and redundancy. This Rule 2 presumes that the Senate trial will have testimony, giving rise to such questions. Rule 11 authorizes the full Senate to designate a committee of senators.
Steve Parkinson says, so does this have anything to do with laws or just a popularity contest? Well, it's kind of a popularity contest, yeah. If it's a popularity contest, charging with crime is not a point anyway. Well, it's only a point in so much as the Constitution says that you should be impeached for treason, bribery, or other high crimes or misdemeanors. And as every lawyer will tell you, if they're being honest, no one has any clue what other high crimes and misdemeanors means, like, at all. We're pretty the consensus, as far as I can tell, is that it definitely includes anything that is a actual crime, and it probably includes some other stuff that are not actual crimes. How much other stuff, though, no one can quite agree on. But it is notable, at least, that this is the first impeachment that I'm aware of the impeachments that have been levied where there was no criminal charge element. I mean, Clinton was charged with perjury and obstruction of justice, both of which are actual criminal charges.
What about the Clinton trial? What about the Clinton trial, it will be argued?
2 12-hour days was what Clinton was.
Departing from every other impeachment trial
Noted.
In history, including the impeachment of President Andrew Johnson. What about the Clinton trial?
Mr. Ravalli says, as a layman, I assume you need as many witnesses as there are witnesses. You win the prize. No. Yeah, you need as many witnesses as you need.
The process for the Clinton trial was worked
some
out
number.
By mutual consent.
In a murder trial, you don't necessarily need any witnesses because the person could theoretically plead guilty, right? So just saying, like, you don't necessarily need a single witness. It's probably not relevant to our immediate discussion.
All of the documents in the Clinton trial were turned over prior to the trial. All 90,000 pages of them, so they could be used in the House's case. None of the documents have been turned over by the president in this case. And under Leader McConnell's proposal, none may ever be. They certainly won't be available to you or to us during most or all of the trial. If we are,
yeah, Matthew, that was Andrew Johnson, right?
The Senate.
Yeah, that was Andrew Johnson.
On the documents now.
Who's impeached for firing someone, and Congress got ticked.
Third,
violation of the Tenure in Office Act was one of his charges, right?
But of
I think I've got that right.
All of the key witnesses in the Clinton trial had testified before the grand jury.
Jake the Hammer says, I was kind of hoping Roberts would wear those dorky striped robes. Rehnquist didn't just wear that when he was doing the impeachment trial. Rehnquist wore that when he was Chief Justice. As I understand it, It's been a while since I've read it, but those stripes on that cloak or on the robe were from a play or some sort of musical or something. It was part of a costume in a play or something that Rehnquist saw, where the guy was playing a judge of some kind, and Rehnquist apparently liked it, and so then decided to start wearing it as Chief Justice. He was the only one who ever did that with the stripes, but he wore that on the bench all the time. That was not just a Senate thing. That was a Rehnquist thing. And Roberts, probably very judiciously, in my view, decided not to carry on with that particular tradition of Rehnquist. Not sure why Rehnquist thought it was fashionable, but okay.
If we're really serious about modeling this proceeding after the Clinton trial, the Clinton precedent is one where all the documents had been provided up front, where all the witnesses had testified up front prior to the trial. That is not being replicated by the McConnell resolution, not in any way, not in any shape, not in any form, far from it. The traditional model followed.
So let me get this straight.
And all of the others.
Let me get this straight, Mr. Manager / Mr. Prosecutor. You're upset with the Senate Majority Leader and the way he's made certain rulings, and so your tactic in your opening statement is to badmouth the Senate Majority Leader, who is leader for the majority. Your strategy is to badmouth the Majority Leader to the jurors, who that's their leader. Okay. Doesn't strike me as the best litigation tactic I've ever heard of in my life.
President's obstruction and encourages further future presidents to defy lawful process in impeachment investigations. Second, if the president wishes to contest the facts and his answer and trial brief indicates that he will try, he must not continue to deny the Senate access to the relevant witnesses and documents that shed light on the very factual matters he wishes to challenge. The Senate trial is not analogous to an appeal where the parties must argue the facts on the basis of the record below. There is no record below. There is no below. This is the trial. Third, the president must not be allowed to mislead the Senate by selectively...
Well, there could have been a below. You know, you could have gathered evidence and records and stuff and handed it over to the Senate, like, you know, you were supposed to do. That's an idea. You know, you are the investigative group. So that's an interesting idea. There is no below. Well, that's the rough equivalent of a prosecutor going to a jury and saying, well, there can be witnesses and there can be evidence introduced here. Now, you may want to know about the evidence and witnesses that the police interviewed, but they didn't interview any police. There is no below. There were no witnesses and no evidence gathered by the police. But that's not a problem because you, the jury, can hear evidence for the first time. And I, as the defense lawyer, am thinking, what? You don't have evidence? First of all, how did we get this far? Second of all, as soon as you're done talking, and probably before, I'm going to move to dismiss. So, we don't have any evidence. Our investigation didn't turn over anything. You know, our police and, you know, our people couldn't. There is no below. We don't have any evidence of any crime. We're still charging this guy, though. And you should want witnesses, because there are witnesses in a murder trial. You know, witnesses we could have developed and identified in our investigation, so you would know who to call. But, you know, they're just witnesses in murder trials. So, you know, the fact that we don't have any witnesses isn't a problem. You know, you should just create witnesses, because murder trials have witnesses. The fact that we don't know who they are, that's not a problem, even though I'm the prosecutor.
And film, the truth will come out. The question is,
bye, evil coleslaw.
And what answer shall we give if we did not pursue the truth now and let it remain hidden until it was too late to consider on the profound issue of the...
What is this like that he's displaying on? Is this PowerPoint or what is this exactly?
There are many overlapping reasons for voting
Is this
against
PowerPoint?
resolution.
What is this being displayed?
Fairness. The trial should be fair to the House, which has been wrongly deprived of evidence by a president who wishes to conceal it.
Yeah, Riley. Our investigation didn't turn anything up, and yet he still hasn't confessed. What is he hiding?
Acquittal or dismissal.
Yeah.
If the trial is not viewed...
Ewim, you have a stream? I didn't know you have streams, Ewim. What stream do you have?
It is not viewed as impartial.
Ewim has a stream?
And fair to you senators who are tasked with the grave responsibility of determining whether to convict or acquit, and should do so with the benefit of all of the facts. And fair to the American people who deserve the full truth and who deserve representatives who will seek it on their behalf. And with that, Mr. Chief Justice, I yield back.
Oh, good. He stopped talking. Yay.
Mr. Cipollone, Mr. Sekulow, you have 57 minutes available.
57 minutes.
Thank you, Mr. Chief Justice, members of the Senate, Leader McConnell, Democratic Leader Schumer. It's also my privilege to represent the President of the United States before this chamber. Senator Schumer said earlier today that the eyes of the founders are on these proceedings. Indeed, that's true. But it is the heart of the Constitution that governs these proceedings. And what we just heard from Manager Schiff, courts have no role, privileges don't apply. What happened in the past, we should just ignore. In fact, Manager Schiff just said, try to summarize my colleague's defense of the president. He said, not in those words, of course, which is not the first time Mr. Schiff
nice
has
trick.
put words into transcripts that did not exist.
Nice burn. Not the first time you put words in someone's mouth. Oh, nice burn. That's a nice little touch there. I like it. This is a very strange kind of opening statement to react to. I don't know how this should be evaluated. Should I evaluate this like a legal speech or like a PR speech or like a Toastmaster speech? I'm not sure quite how to evaluate this.
The president was denied the right to have counsel present at hearings. That's a trifecta. A trifecta that violates the Constitution of the United States. Mr. Schiff did say the courts really don't have a role in this. Executive privilege, why would that matter? It matters because it's based in the Constitution of the United States. One manager said that it is you that are on trial, the Senate.
I wonder if Alexandria Ocasio-Cortez is really butthurt that she wasn't named as one of the managers. I just wonder if that, like, it had to have come up at some point. She's entitled enough to want to be like one of the managers, to get over there and screech in the face of the Senate. Of course, she's not on the good kids. She's not on the cool kids club with Pelosi right now, so that was not going to happen. But I wonder if like she asked, it's like, can I be a manager? Can I be a manager, Nancy Pelosi? I want to go over there and I want to explain to the Senate how bad Trump is. I'm almost sad that didn't happen, to be honest. That would have been hilarious.
Trial and impeachment inquiry is not a criminal trial and should not be confused with it.
Jake the Hammer says it's like if a debate between candidates were more formalized. That's probably the best way to put this. It's probably like a formalized debate. Yeah, it's probably more in that line than anything else. Yeah. So it's probably more in line of like a policy debate or Lincoln Douglas debate or something like that. So I'll break out my scoring chart from my high school debate days, and we'll go with that, right?
When the Russia investigation failed, it devolved into the Ukraine. A quid pro quo. When that didn't prove out, it was then bribery or maybe extortion, or somebody said, one of the members or the members of the House said treason.
There was an earlier comment from Iredell said is there some sort of jury selection part? Vote to kick away persons that aren't fit to be a juror. No, not in this case. The jury is the Senate by the constitutional terms. So there is no jury selection process because the jury is pre-established. The jury is the Senate. So as a result of that, there's no such thing as dequalifying. There's no such thing as kicking someone out because they're unfit. There's no such thing as kicking someone out because they're biased. There's no such thing as kicking someone out because of conflict of interest. A senator can recuse themselves, which I don't know if this ever happened in the history of ever, but theoretically they could. So no, there is no process of jury selection. The people of the United States did that already when they voted for the senators. So there's that.
With respect to the Holder contempt proceedings, Mr. Manager Schiff wrote, "The White House assertion of privilege is backed by decades of precedent that has recognized the need for the president and his senior advisors to receive candid advice and information."
Yeah, so the idea of like executive privilege, presidential privilege is not exactly a novel concept, right? This goes back, and of course it has been tested and had its limits, and perhaps most notably had its limits in the Nixon case, but the idea that the president has to have some kind of privilege because he has to have the ability to speak to his advisors completely candidly is not, of course, unprecedented. The exact boundaries of that are, as always, open to debate. Is there any way they can get the feed louder? Sure.
What are we dealing with here? Why are we here? Are we here because of a phone call? Or are we here before this great body because since the president was sworn into office...
Is it loud enough, or do you need it louder still?
There was a desire to see him removed. I remember in the Mueller report, there were discussions about, remember, insurance policies. The insurance policy didn't work out so well. So then we moved to other investigations. I guess you would call it reinsurance or an umbrella policy. And that didn't work out so well. And here we are today. Manager Schiff quoted the Supreme Court, and I'd like to make reference to...
A. Hedinger's absolutely correct, right?
Well.
One of U.S. Nixon said, one of the privileges is diplomatic and one of them is military. So this is like a twofer. You know, so it would fall into the scope of privilege.
We may someday be presented with a situation in which the conduct of law enforcement agents is so outrageous that
Chief Justice doesn't get to break the tie, and it can't break. You need a 2/3 majority by the Constitution. So it's not an issue of 50-50. You need 2/3. So you need 67 if everyone votes. Which means, for those of you doing math at home, you need 20 Republican senators to break and vote to convict.
Review, and I will do it later.
So there's that.
The pattern and practices of irregularities that have gone on in these investigations from the outset.
You need 2/3. So.
But to say that the courts have no role, the rush to impeachment, to not wait for a decision from a court.
Who wants to think that we're going to get 20 Republicans to vote, we should convict?
Executive privilege
probably not so much.
Hasn't been utilized by presidents since our founding. This is not some new concept. We don't waive executive privilege, and there's a reason we keep executive privilege, and we assert it when necessary. And that is to protect.
What do the Democrats hope to achieve? I honest to God don't know. I honest to God don't know. And, you know,
the president's opponents in their rush
conservative.
To impeach have refused
I'm
to wait
Republican.
for complete judicial review.
I honest to God don't know what the Democrats hope to show.
Speaker Pelosi clearly expressed her impatience and contempt for judicial proceedings when she said,
the best answer I can give to that was Nancy Pelosi when she was on Bill Maher recently, which I recommend just because it's so serious and so solemn, and she's half giggling like a schoolgirl. She's so happy she gives Bill Maher a fist bump on air about the impeachment and says he's impeached forever. I think it's like they feel like it's a moral retribution or moral condemnation, and somehow that's enough. And they also, I suppose, hope it's going to in some way impassionate their base or
It was
something.
interesting when Professor Turley
But I
testified
don't really
before the
know
House
what the
Judiciary Committee in
political
front of Mr.
advantage
Nadler's
for the
committee.
Democrats is.
He said we have 3 branches of
It
government,
all
not
seems like
2. If you
it all
impeach a
seems like
president, if you
downside to
make a
me.
high-crime and misdemeanor
Well,
out
the
of
only
going
other
to
thing that
courts and
makes
abuse
it
of
like
power, it's your abuse of power.
interesting thing for the Democrats
more than
is
that.
when this inevitably ends
A lot more than
in
that.
acquittal with 0 Republicans
There's a lot
voting
more
in
than
favor,
abuse of
might
power
I
if you
add,
say the courts
that
don't
they get to
apply.
run ads basically
Constitutional
saying,
principles don't apply.
look how biased the
Let's
Republicans
start with
are.
a clean slate as if nothing happened.
You know, we know what's
A
true
lot
and
has
we
happened.
can't get them
As we
to admit the
proceed
truth, and they can't stand by their own principles. So maybe it's
in the
good for
days
some.
ahead, we will lay out our
Maybe
case.
it's good for some generic negative attack
We're
ads
going to
against
put forward
Republican
to
candidates
the American
or
people,
something.
but more important,
You
for
know,
the Constitution's
so
sake, what's taking place here. But this idea that we should ignore
yeah, Matthew says if you had a vote
has
to
taken
100 to
place over the
200,
last
it's
3
2/3. Yeah, that's 2/3.
is outrageous.
Yeah,
We
that
believe
would be 2 out of 3.
what Senator McConnell has put forward
Yeah, you need 2/3, so that would
provides
be
due process,
exactly 2/3, which is incidentally why
allows
you
the
need 67,
proceedings
because
to move forward in an orderly
66.6, you can't get a fraction of a
33
vote.
days.
So you get to have 67.
33 days.
But
they held
yeah,
on
if you
to
could
those
get exactly 2/3, then sure,
33
then
days.
that would work.
There was such a rush of national security to impeach this president before
I'm not really
Christmas
sure what
that they then held him for 33 days.
political
To do
advantage
what?
there is to this. Maybe someone who's more
To
left-leaning
act
and
as
more
if they
democratic
negotiate
thinking
the House
can
of
explain to me what they
Representatives
think the advantage is.
should negotiate
Looking good
the
to their
rules
base, but like, I don't
the
know
United
how
States
much it
Senate.
would have
They
helped.
didn't hide
I don't
this.
know how much difference it makes.
This was the
like
express
versus
purpose.
not impeaching and versus
This was
impeaching.
the reason they
Like,
did
how
it.
much does it
We're prepared to
re-energize
proceed.
their base? How much does it like
Majority Leader,
cause people
Democratic
to
Majority
like
Leader,
come out to
we're
the polls
prepared
or
to
something?
proceed.
I don't really see the
In our view,
advantage in terms of like.
These proceedings should begin. Yield the rest of my time to my colleague, White House counsel.
Oh, good. He only talks for like 10 minutes, 15 minutes, and then he's going to defer to the White House
Thank you,
counsel.
Mr.
Good for
Chief
him.
Justice.
Anyways,
I just want to make a couple of
So
additional
yeah, that's kind of what I think
points.
about that. This is this
It's
is a
very
PR campaign
difficult
live on television.
to
That's
sit
basically
there
what this is.
and
yeah.
listen
This
to
is just
Mr.
PR on
Schiff
television.
tell the tale.
I
that
love
he
this
just
guy's
told.
hair. Let me just say,
Let's
Pat.
remember how we all
This
got
guy,
here.
I love this guy's hairstyle.
They made false
I think I even like this guy's
allegations
tie.
about a telephone call. The President of the United States declassified that telephone call.
When this is all over, the
and released it
Republicans
to the
start
public.
investigating.
How's
yeah,
that for
that's what I said.
transparency?
I said that I said the Republicans in
Mr.
the
Schiff
Senate were
found
going to
out
announce any
that
day
there were
now
there was
the
nothing
start
to
of the
his
impeachment
allegations.
inquiry into the yet to be
He
determined
focused
next
on
Democratic
the
president
second
of the United
telephone
States.
call. He made false, and his colleagues made false.
Because I think
allegations
in the
about
event
that
that Trump gets elected,
telephone
which
call
let's all be
that
honest with,
occurred before the one
each
he
other,
had demanded.
is not exactly zero. There's a pretty decent
So the
chance of it from
President of the United
where I'm
States
sitting. You know, it depends on a lot what happens
declassified
between now and then, but
and released that telephone
you
call.
know, I think Trump's odds of getting reelected are pretty
Still
good.
nothing.
If he does get reelected,
Again,
I don't think this
complete
is going to be the last
transparency in a
impeachment
way
hearing.
that, frankly,
I think the House
I'm
is going to impeach
unfamiliar
again,
with any precedent of
and
any
we're gonna do
president
this
of the
again.
United States
and then
releasing
we
a
just have a
classified
precedent of
telephone
perpetual
call with a
impeachment
foreign leader.
inquiries.
When Mr. Schiff
I also
saw
love the fact that there's
his
a very
allegations
decent
were
chance
false,
that the
and he knew
impeachment
it anyway.
trial is
What did he
occurring
do?
while President
went to
Trump
the House.
is giving the State of the Union address
And he
to a joint session of
manufactured
Congress. So I know normally I wouldn't tune in
fraudulent version
to the
of
State of
that
the Union
call.
because normally I find
He
it to be too much political
manufactured a
theater.
false version of that
You know,
call.
in the
He
unlikely
read it
event
to
I
the
ever become
American
president,
people,
I
and he
probably would
didn't
not
tell
give a
them
State of the
it
Union
was a
address. I'd
complete
actually just
fake.
do it on paper because I find it to be a
You
little
wanna
bit
know
too
about due process?
monarchical,
I'll tell you about due
monarchical
process.
in terms of its presentation style.
Never before in the history
So I
of
probably
our
wouldn't do
country
it.
has a president been
I'd probably just do
confronted
it with paper.
with this kind of
And you know, I could still give
proceeding
speeches
in
and
the
stuff. So
House.
like I still give like a State
It
of the Union
wasn't
speech. I just
conducted
wouldn't
by
give
the
it to
Judiciary
Congress.
Committee.
I give it to like
Now,
as a
Mr.
primetime
Nadler,
address
when
or
he
something,
applied
where
for that
I'd
job, told
give
his
it the next day or
colleagues
something.
when
I
they
just
took
wouldn't do it
over
to
the
Congress
House
because
that he
I
was
don't
really
like
good
the
at
format of it
impeachment.
personally.
But
But
what
yeah, this
happened
State of the
was
Union address is going to
the
be
proceedings
off the
took
chain
place in a basement
because
of
the
House
impeachment inquiry is going to be
of
ongoing.
Representatives.
So
The president
I wouldn't normally tune
was
in, but I
forbidden
think tuning in
from
this year is going to
attending.
be.
The president was
It's going to be
not
good,
allowed
guys.
to
I think
have
you
a
should get
lawyer
some liquor
present.
and some bingo cards
In
because I think it's
every
going to be a
other
good time.
impeachment proceeding, the president has
Let's
been
assume he
given
gets
a
impeached. Can he get
minimal-
reelected? It
mi-
depends
minimal
on what
due
the Senate
process.
does.
Nothing here.
The Senate,
Not
Senate,
even
once they convict,
Mr. Schiff's Republican
has to
colleagues
make a separate
were
vote
allowed into
to
the SCIF.
disqualify from further office.
Information
It is
was
one of the
selectively
sanctions the
leaked
Senate
out.
can give. So when they convict, it throws him out of office.
Witnesses were threatened.
To disqualify him from
Good
holding
public
further
servants
office
were
requires a
told
second
that
vote.
they would be held in
Now that
contempt.
vote only requires a 50%
They were
vote.
told that they were
So it's a little hard to imagine
What
a
does Mr.
scenario
Schiff
where
mean
you can
by
get
obstructing?
2/3
He means
to convict,
that unless you
but you
do
can't get 50%
exactly what he says,
to disqualify.
regardless
But
of your
technically speaking,
constitutional
it's
rights,
possible.
Then you're
So
obstructing.
technically speaking, they could impeach, convict,
The
and
president
not
was not
disqualify, and
allowed
then he
to
would
call
still be
witnesses.
eligible to run again.
By
But
the
that's not
way,
happening either.
There's still
But technically
evidence
it's
in
possible.
the skiff that we haven't been allowed to see. I wonder why.
Yeah. The only two penalties the
No
Senate can
witnesses.
dish out
Now
are
let's
throwing you out of
think about
office
something else for a
and
second.
disqualifying
Let's think about
disqualifying you
something
from
else.
holding further office.
They held these articles for
That's all the Senate can
33
do.
days.
Those are
We hear all
the
this
scope of all
talk
their options.
about an overwhelming case. An overwhelming case that they're not even prepared today to stand up and make an opening argument about. That's because they have no case. Frankly, they have no charge. When you look at these articles of impeachment,
Illegred
they're
is
not only
correct that
ridiculous,
yes,
they are
you are correct,
dangerous to our
Illegred. I
republic. And
perhaps
why?
slightly misspoke that there are some
First of all,
collateral
the notion
consequences
that invoking your
to being impeached
constitutional
and
rights
convicted.
to protect
So it's not a sanction the
the
Senate gives
executive
out,
branch
but there
that's
are
been done
collateral
by
sanctions that occur
just
in the
about
U.S.
every
Code.
president
And lateral
since
is
George
correct.
Washington.
Those sanctions include
that
that you no longer get Secret
is
Service
obstruction.
protection and you no longer get your pension.
That is our
So
patriotic duty,
that is absolutely true.
Mr. Schiff. Particularly
It is
when
not true
confronted
if you resign. It's
with
only
a
true if
wholesale
you are
trampling of
convicted.
constitutional rights.
But
that
you're correct.
I'm unfamiliar
Now, I'm not
with
quite sure what happens in the
this
scenario
country. Frankly, it's
if
the
you're
kind of
impeached,
thing that our
convicted,
State Department would
removed,
criticize
and not
if we
disqualified,
see it in foreign
and then you
countries.
run and re-win
We've never
election.
seen anything like it.
Presumably,
and Mr. Schiff said, "Have I
you still
got a
get Secret
deal for
Service
you?
protection. I would imagine.
Abandon all your
But
constitutional rights.
it's never come up, and it's not going to come up now.
Forget about your lawyers.
Matt, no, you cannot disqualify without
And
throwing
come
you out
in
of
and
office.
do
You can't do that.
exactly
You
what I
have to
say.
convict first,
No, thank you.
and then you can decide
No,
whether or not
thank
to
you.
disqualify.
And
But you
then
cannot
he says
disqualify without
he has the temerity
conviction, no.
to come into the Senate and say, we have no use for courts. It's outrageous.
Out of all the current
Now, let me
Dems, the
tell you
only one who
another
stands any
story.
chance is Pete Buttigieg.
There's a man
Personally,
named
I
Charlie
think
Kupperman.
Andrew Yang
He is the deputy
or
national security advisor.
Tulsi Gabbard
He is the number 2
would have
to
a
John
pretty
Bolton.
decent shot against Trump.
Because you have to remember, Mr. Schiff
but
wants
that's
you to
just me.
forget, but you have to remember how we got here. They threatened him. They sent him a subpoena.
I'm a bit of an Andrew Yang fan.
Mr. Kupperman did
I-
what any
I would probably vote for
American
Andrew
should
Yang
be
if
allowed
he
to do, used to be
became the
allowed to
nominee.
do.
And I'll vote for him in the primaries
He was
because why not?
forced
But
to get a lawyer. He
yeah,
was
I'm a bit of
forced
an Andrew Yang
to
fan.
pay
I
for
like
that
his
lawyer.
philosophies. I like his thinking.
And he went to court.
He's a reasonable guy. He's not
Mr.
deep
Schiff
into
doesn't
identity,
like courts.
identity politics, and he has well thought out positions.
He went to
I
court.
really like. So I like Yang.
And he said, Judge, tell me what to do. I have obligations.
Illegrid is also correct.
that
Illegrid is also
frankly
correct. You
rise
are
to
correct.
what the Supreme Court has
You can
called
technically
the
be
apex
you
of
can
executive
technically be
privilege in the
impeached
area of
and
national
convicted
security.
even
And
after
then
you're no longer in
I have a
office.
subpoena
There was that
from
part of
Mr.
the
Schiff.
Nixon
What do I do?
decision, or was it part of
You know what Mr. Schiff
Johnson?
did?
Or it definitely came up once before.
Mr.
It's in the
Kupperman
Senate rules.
went to the
But
judge.
yes, you are
and the
correct
House
that
said,
technically speaking,
never mind.
resigning does not
We withdraw the
prevent the
subpoena.
Senate from impeaching, convicting, and
promise not to
disqualifying
issue
you.
it again.
You are correct. The impeachment power of Congress does
And then
persist
they come
past
here
resignation.
and they ask you
So yes, if Trump resigned,
to
they
do
could
the
still
work
convict him and still
that
disqualify
they
him
refuse to do for
according to
themselves.
the law. So you
They ask
are
you
correct.
to trample
You are correcting
on
me
executive privilege. Now,
in many
would
ways.
they ever suggest
You get a cookie.
that the executive could determine on its own what the speech or debate clause means? Of course not. Would they ever suggest that the House could invade the discussions that the Supreme Court has behind closed doors? I hope not. But they come here and they ask you to do what they refuse to do for themselves. They had a court date. And they withdrew the subpoena.
Speaking of which,
they
I should
evaded
file
a
for my
decision,
absentee ballot.
and they're
so I'm just
asking
going
you
to
to
go ahead and
become
do that in a separate
complicit
window while you
in
guys
that
are talking
evasion
amongst
of the
yourselves.
courts. It's ridiculous. And we should call it out for what it is. Obstruction for going to court? It's an act of patriotism to defend the constitutional rights of the president, because if they can do it to the president, they could do it to any of you, and they could do it to any American citizen, and that's wrong. And Lawrence Tribe, who's been advising them, I guess he didn't tell you that in the Clinton impeachment he said it's dangerous to suggest that invoking constitutional rights is impeachable. It's dangerous. And you know what? It is dangerous, Mr. Schiff. So what are we doing here? Okay. We have the House that completely concocted a process that we've never seen before. They locked the president out. Oh, and by the way, will Mr. Schiff give documents? We asked him for documents. We asked him for documents when, contrary to his prior
when is
statements,
the March Democratic primary? I need to figure out if I'm actually going to be a resident
was
in March.
working with the whistleblower.
In March or not.
We said, let us see the documents, release them to the public. We're still waiting. So the
March the
idea
3rd?
that they would come here and
that's
lecture
pushing
the
it.
Senate. By
That's
the way,
pushing it.
I was surprised to hear that.
All right, I have to figure out whether or not I'm still a legal resident as of
Mr.
March the
Nadler's
3rd or
putting
not.
you on trial.
I'll have to get back to you on that one.
Everybody's on trial except for them. It's ridiculous. It's ridiculous. They said in their
Matthew
brief,
says, how many does it
we
take to
have
impeach a federal judge? Is it
overwhelming
2/3? Yes, it
evidence,
is. It's 2/3.
and they're
2/3
afraid
for
to
any
make
impeachment.
their case.
Are any senators listening to this? Probably not.
Think about
They
it.
do
Think
kick him out
about
when
it.
that would
It's
take
common
place
sense.
immediately. Immediately, it would take place instantly.
Overwhelming evidence to impeach the president of the United States.
UBI is too similar
And
to
then they
socialism,
come here
easily
on the
framed as
first
such.
day,
Not
and
the
they
way
say,
I see it.
"You
I
know
mean,
what? We need some evidence."
socialism
Now, let me tell you
is
something.
state
If I
ownership
showed up in
of
any
the
court
means
in
of
this
production,
country,
right?
and I said,
so UBI
Judge, my
is
case is
essentially,
overwhelming, but I'm not ready to go yet.
and you can
I
be
need
viewed
more
as like a
evidence
negative income
before I
tax.
can
So
make
I
my
don't think it
case.
fits into the
I
socialism
would
model.
get thrown out.
And
in
it's an
2
interesting
seconds.
proposition
And
from
that's
a Republican
exactly what should
standpoint
happen
because
here. That's exactly what should happen here.
you know, we already have all these welfare and
It's
assistance
too much to
programs,
listen to,
and
almost.
so if
The
you
hypocrisy
took all that and you replaced it with UBI, it
the
would be a
whole
lot more
thing.
efficient. So it
And
has
what
some
are the
appeal to
stakes? What are the
Republican conservative
stakes?
economic principles.
There's an
Milton
election
Freeman was a bit of a fan of it
in
for
almost
similar
9
reasons.
months.
So you
Months
can
from now,
view
there's
it
gonna
as
be an
positive from
election.
conservative principles too. Yeah.
Senators in this body the last time had very wise words. They echoed the words of our founders.
Mr. Ravlin said Tulsi's out of the race at this point,
A
and Yang has no
partisan
chance because of all schemes of getting
impeachment
votes were incredibly short-sighted.
is like stealing
Trying to force his means
an
was one of the
election.
stupidest ideas he had. I don't know. Anything to get
That's
attention,
exactly
get your name
what
out.
we
I don't
have.
think it was that stupid.
We have, talk about the
Yeah,
framers'
Yang's
worst
version
nightmare.
is kind of a tax credit. Yeah, that's kind of
It's a
yeah.
partisan impeachment.
Like, you know, we already
that
have a
they've
big
delivered to
pool of
your
money
doorstep.
for all the government
In an election
welfare,
year.
subsistence,
Some of you are upset because you should be in Iowa
entitlement
right
programs
now.
that are out there, right? So
But instead, we're here,
you can say, we'll just take the same big
And
pool
they're
of
not
money and
ready to go.
redistribute it a
and
different
it's
way.
outrageous. It's
So,
outrageous.
And that
And
becomes
the
a lot
American
easier
people
to
won't
administer
stand
because
for it.
then
I'll tell you
instead
that
of,
right now.
you know, God
They're
knows
not
how
here to
many
steal one election.
government
They're here to
programs you
steal
need
2
and how many
elections.
government agencies you need
It's
to
buried in the
review
small
it
print
and
of their
make sure people are in
ridiculous articles of
compliance
impeachment.
and all that good stuff.
They want to remove
You don't have to have
President
all that
Trump from the
anymore.
ballot. They won't
You
tell
just mail
that.
everyone a check.
They don't have the guts to
No
say
questions
it
asked.
directly. But that's exactly
So it's a lot easier
what
to
they're
administer.
here to do.
So that's
They're
nice.
asking
That
the
shrinks the size
Senate
of government. So that's a plus from conservative legal
to
thinking
attack
too.
one of the most sacred rights we have as Americans, the right to choose our president.
Is the House like a grand jury deciding the person is
In an
accused or
election
not?
year.
Yeah, that's a good way of thinking about
It's
it. Is the
never
Senate
been
like
done before.
the real court case? Isn't there
It
something like
shouldn't be done.
discovery? Or is it
Now,
a civil criminal difference?
the
Well,
reason it's
discovery
never
exists
been
in both
done
civil
is
and criminal
because
cases.
No one ever thought
Discovery,
that it would be a good idea for our country.
I guess,
our
doesn't really
children,
take place
our
in the same way
grandchildren.
because it's a lot more open
try to
than
remove a
normal
president from a
processes, right?
ballot.
Because the president and his
deny the
counsel
American
are obviously
people
reviewing the stuff. There's
right
like
to vote
they could see all the evidence, right?
based
Because it's
on
part of
a
the congressional
fraudulent
record.
investigation
So there's not really
conducted in
discovery
secret with
because
no
it wouldn't make any
rights.
sense.
Well, I could
because
go on and
everything
on.
is already
But
in the
my
record.
point is very
So
simple.
I don't know that
It's long
the concept
past
of discovery
time
makes any sense, but to
that
the
we
extent it
start
would,
this
you know,
so
you
we
can
can
get
end
subpoenas
this
and stuff from the
ridiculous
Senate side
charade
if you're the president and stuff
and
like
go
that.
have an election. Thank you very much, Mr. Chief
Yeah.
Justice.
The Senate is like a court case. The Senate can be best thought of as a court, and the
Does the President's
senators as
counsel yield
judges.
back the remainder of their time?
So
Thank you.
Chief Justice Roberts probably wants to be anywhere
The Democratic
else.
leader is recognized.
Oh, well, he's done too.
Mr. Chief Justice, I send an amendment to the desk to subpoena certain documents and records from the White House, and I ask that it be read.
The clerk will read the document.
Fair point, Mr. Revalia. Fair point. Maybe it was a
Senator
mistake.
from New York, Mr. Schumer, proposes an amendment number 1284. At the appropriate place in the resolving clause, insert the following. Section, notwithstanding any other provision of this resolution pursuant to Rules 5 and 6 of the Rules and Procedure and Practice in the Senate when sitting on impeachment trials, 1, the Chief Justice of the United States, through the Secretary of the Senate, shall issue a subpoena to the acting Chief of Staff of the White House, commanding him to produce, for the time period from January 1st, 2019 to the present, all documents, communications, and other records within the possession, custody, or control of the White House, including the National Security Council, referring or relating to A, all meetings and calls between President Trump and the President of Ukraine, including documents, communications,
Iridiel says
and
with
other
discovery you get
records
more evidence during the
related
case
to
by demanding it
scheduling
from the
of,
parties. Yeah,
preparation
discovery
for,
happens before the
and
trial
follow-up from the President's April
starts,
21st
and it's part of
and July
getting evidence from the
25th,
other side.
2019
So it's
telephone
like, get me
calls,
documents, get me
as
records.
well as the President's
Let me know who
September
you're gonna call,
25th,
blah, blah, blah.
2019
Yeah.
meeting with the President
So,
of Ukraine
but
in New
here
York.
discovery
B, all
doesn't really make sense because
investigations,
all the
inquiries,
all the
or other
process is
probes
happening in
relating
the
to
open,
Ukraine,
right? So the
including
grand
any that
jury is in
relate
the
in
open,
any way
which is
to,
like a bizarre
1,
concept, but
former
that's kind of
Vice
where we
President
are.
Joseph
So
Biden,
like
2,
that,
Hunter
therefore,
Biden
the
and
need
any
for
of his
discovery doesn't really
associates.
apply. It's like, what would you be
3,
discovering?
Burisma Holdings
So,
Limited,
you know,
also
that's
known as
kind of the thing
Burisma.
there.
4, interference or involvement by Ukraine in the 2016 United States election. 5, the Democratic National Committee, or 6, CrowdStrike. C, the actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military
this is
assistance,
a
or security
amendment to the
assistance of any
rules that
kind
would
to
allow
Ukraine, including
subpoena
but not
for additional
limited
stuff.
to
The Senate's
the
about to
Ukraine
vote no on
Security
this, but, you
Assistance
know,
Initiative,
fine.
USAI, and foreign military financing, FMF. D, all documents, communications, notes, and other records created or received by Acting Chief of Staff Mick Mulvaney, then National Security Advisor John R. Bolton, Senior Advisor to the Chief of Staff Robert B. Blair, and other White House officials relating to efforts
I have very
to,
mixed feelings about
1,
NCAA
solicit, request,
paying
demand,
college
induce,
athletes.
persuade, or coerce
Yeah, it's
Ukraine
a
to
bit of
conduct
a
or announce
collision
investigations.
of principles
2,
for me.
offer, schedule, cancel,
'Cause
or
it's
withhold
like-
a White House meeting for Ukraine's
it's
president.
sort of, assuming
or
we hadn't
3,
already passed
hold
that
and then
point,
release
it
military and
somewhat
other
corrupts the
security
collegiate
assistance to
purpose.
Ukraine.
Because
E,
you know, they have to-
meetings at or
they should,
involving
in
the White House
principle,
that
be
related
students
to
first, and it's
Ukraine,
like,
including but
I'm not
not
sure about
limited
paying
to 1, President Zelensky's inauguration on May 20th, 2019 in Kiev, Ukraine,
But it is a bit
including
of
but
a
not limited to President
quandary.
Trump's decision to not to attend, to ask Vice President Pence to lead the delegation, directing Vice President Pence not to attend, and subsequent decision about the composition of the delegation of the United States. 2, a meeting at the White House on or around May 23rd, 2019, involving, among others, President Trump, then Special Representative for Ukraine negotiations, Ambassador Kurt Volker, then Energy Secretary Rick Perry, and United States Ambassador to the European Union, Gordon Sondland, as well as any private meetings or conversations with those individuals before or after the larger meeting. 3, meetings at the White House on or about July 10th, 2019, involving Ukrainian officials Andrei Yermak and Oleksandr Danilyuk, and United States government officials, including but not limited to then National Security Advisor John Bolton, Secretary Perry, Ambassador Volker, Ambassador Sondland, to include at least a meeting in Ambassador Bolton's office and subsequent meeting in the war room.
I don't believe the
4, a meeting at the White House on or around August 30th, 2019, involving President Trump, Secretary of State Mike Pompeo, and Secretary of Defense Mark Esper.
To say
5,
for certain.
a planned meeting later canceled in
I would
Warsaw,
imagine
Poland,
if there's a student
on or
athlete
around
somewhere
September
who wants
1st,
to get a side job at,
2019,
like,
between President Trump and
wherever,
President
that they
Zelensky,
can get
and
paid for that,
subsequently
I would
attended
think,
by
but I
Vice
don't know.
President Pence. And 6, a meeting at the
No,
White
there's no
House on
testimony
or
yet.
around
Yeah,
September
we're well
11,
into- we're still well in
2019,
opening statements world.
involving President
no
Trump,
testimony
Vice
of any
President
kind.
Pence, and Mr.
Also, it's very
Mulvaney
unlikely
concerning
that
the
if there is
lifting
testimony,
of
it's
the
actually
hold
going to
on
be,
security
like,
assistance
people
for
testifying
Ukraine.
in the Senate chamber. When
F,
they did it during the
meetings,
Clinton
telephone calls, or
impeachment trial,
conversations
they-
related to
they
any
happened
occasions
as
in which
essentially
the National
depositions.
Security Council
They didn't
officials
happen on the
reported
Senate floor.
concerns
It
to
would be
National Security Council
really
lawyers,
weird
including but not limited
try to have
to
a
National
witness
Security Council
testify
legal
in the
advisor
Senate
John
floor.
Eisenberg regarding
That'd be just,
matters
like,
related to
really
Ukraine,
awkward.
including but not limited to 1, the decision to delay military assistance to Ukraine, 2, the July 10th, 2019 meeting
Yeah, so the
at the White
UBI
House
has a
with
lot of
Ukrainian
attractive qualities.
officials.
You know, it
3,
has attractive
the President's
qualities
July
from
25th,
left-leaning thought because it
2019
helps out the
call
least
with the
possessed,
President of
right?
Ukraine.
It
4, a September
funnels money
1st,
to the
2019
poorest,
meeting
and
between
even if you're giving
Ambassador
everyone the
Sondland
same,
and a
the poorest
Ukrainian
are the
official.
most
And
benefited.
5,
If you give everyone $1,000 a
President's
month,
September
those
7,
making less
2019
are getting
call
effectively
with
a higher
Ambassador
percentage
Sondland.
because
G,
it's more of their
any internal
other income
review
they
or
otherwise would get.
assessment
So
within the
it
White
is,
House regarding Ukraine matters
a nice
following the
position from
September
the left
9th,
because it is,
2019 request for
favors
documents from the House
the-
Permanent Select
favors the
Committee
most
on
poor, the
Intelligence,
easiest. And there's no
the
cliffs,
House
there's no
Committee on
cutoffs,
Oversight
which
and
is a problem with
Reform,
many
and the
welfare
House
programs
Committee
now.
on Foreign
I actually ran to
Affairs,
a person the other
including
day
but not limited
who was
to
talking to me about this problem.
documents
and I know exactly
collected
what
that
problem they're talking
pertain to the
about.
hold on
So this
military
person
and other
is a parent
security
of special
assistance
needs
to
kids,
Ukraine,
and
the
she was
scheduling
saying
of a White House
how
meeting
she,
for the President of Ukraine,
can't earn more
and
money.
any
And I was
request
like,
for
oh, because of
investigations
cliffs.
by
And she's like,
Ukraine.
yeah. Because I know exactly
H,
what problem she's
the
talking about.
complaint
You see, the
submitted
problem
by a
is the
whistleblower
way
within the
the government
intelligence
programs are set
community
up now.
on or around
But there's
August
all
12,
kinds of different programs,
2019,
right?
to the
So there's all
Inspector
kinds of
General
different
of the
programs and all
intelligence
kinds of
community.
different
I, all meetings or calls, including
rules for these
requests
different
for
programs, different
or
income
recordings
cutoffs
of
and
meetings
stuff.
or
So
telephone
it
calls,
can become very much the
scheduling
case
items,
that by
calendar
earning more
entries,
money,
White
you
House visitor
lose one
records,
program
and
but don't get
email
enough
or text messages
compensation
using personal or
to make
work-related
it
devices
profitable. So you're
between
actually
or among
worse off by earning
1,
more.
current
And
or
that like
former
should
White
never be
House
true, right?
officials
You
or
shouldn't be worse off by earning more.
including, but
We
not
should never
limited
discourage
to,
people from
President
earning more
Trump,
money.
And
This
2,
is bad. We shouldn't
Rudolph
incentivize
W.
people to earn
Giuliani,
less.
Ambassador Sondland,
This is bad.
Victoria Tunsing,
So one of the nice things
Joseph
about the
DeGenova,
UBI is you don't
and
have
Jay,
the problem anymore.
former United
You know,
States
you don't have to worry
Ambassador
about
to
cliffs.
Ukraine,
You
Marie
always get the money no
Masha
matter what.
Yovanovitch,
And it always helps
including but
you,
not limited
the poorest,
to
the
the
most.
decision to enter,
You know, if you're making
tour,
$1,000
or
a
recall
year,
her from the United States
an extra $1,000 a
Embassy in
month
Kiev,
is
and
12 times your
2,
annual
the
income.
Sergeant at Arms
You're
is
making $1 million a
authorized
year,
to
it's
utilize
nothing,
the
right?
services
So
of the
it's like,
Deputy
okay.
Sergeant at Arms,
So that's the really
or
attractive
any
thing
other
from the
employee
left.
of the United States Senate
It's really
in
attractive from
serving
the right
subpoena authorized to be
because
issued
it
by this section.
is a program that's easily
Mr. Chief
administered
Justice.
and it
Majority
requires a
Leader
lot
is
less bureaucracy and
recognized.
a lot less
I'd
government.
ask for a brief
So rather than
15-minute
having,
recess before the
You know,
parties are
God knows how
recognized
many
to
agencies
debate
and how
the
many
Schumer
programs and how many
amendment.
bureaucrats
Therefore, I ask
doing all the monitoring to
consent
figure out
recess
who is and who is
subject
not
to the call of the
qualified
chair.
and monitoring everyone to make sure they're
Without
in
objection,
compliance with
so
all the
ordered.
rules. That total nightmare. Rather than doing all that, are they done now? Okay, well, they're done for the minute. They're
The
recessed, yay.
impeachment trial of President
But
Donald
we'll continue
Trump
this
underway
discussion.
for
Rather than doing
about
all that,
an
we just
hour
have
and
one
a half.
program,
We heard
and
some
it's really
opening
easy to
remarks
administer
from
program.
White
So
House
it's-
counsel Pat Cipollone,
You know, just the
then
IRS
lead
sends out
manager
checks,
in the
and they
House,
send it out to everyone.
Representative Adam
Send
Schiff,
a check
the
of
chair
$1,000 a
of the
month to every
Intelligence
person
Committee,
over the age of 18
making their
who's a
case,
citizen of
the
the United
initial part
States.
of their case, the
This
opening
is pretty
statements
easy.
there,
This we can
response from
administer. Doesn't require a lot of
the
thought and
President's
process.
attorney Jay Sekulow,
It's
and
like,
also
well, we already
again
know who they
from
are and where
Pat
they live 'cause we're
Cipollone.
getting
Where
tax
things
returns from them,
stand
so that
as
makes
the
it easy.
Senate's
So,
in
no problem.
recess. We expect it to be fairly
And
brief.
it's also nice
Here's
from a
what,
libertarian
Lisa
standpoint.
Desjardins of the,
Now,
NewsHour,
libertarians, of
PBS
course, are
NewsHour
not usually
tweets
a
on what
fan
we
of
just saw,
government
what's
subsidies
happening.
of any
Schumer is
kind.
moving to ask the
But
Senate
to the extent
trial
that they
to
would be,
subpoena key
it's very
documents
nice
and
because it's
witnesses to
unattached
do that.
money.
He needs
You
51
know, the
votes
libertarians
today.
But
won't
swing
like the fact that
senators he
government's
needs
doing
have
stuff,
said
but
they
they
don't
will like
want
the
to
fact
take
that
this
it's
vote yet. Chad
that the
Pergram
money
of
is
Fox says that
unattached.
in
You
the
can use it
Senate
for
trial
any
expect a
purpose.
short recess
So it's
here,
not for a
5
specific
to
purpose,
15
not for
minutes
specific
after
things. You
Schumer
can use
offers
it
his
totally
First
freely.
Amendment.
It's
But
yours.
before the debate on that amendment, he's
Yeah.
also saying
So-
that Fox is being told to expect a very
You can defend
late
it
night.
from
Mitch
right-leaning,
McConnell, the
left-leaning,
majority
and
leader, earlier
libertarian
today made some comments
economic
about the amendments, the proposed
So,
amendments to the resolution.
I think the biggest resistance
from
you'd actually
Senator
get
Schumer.
to the
Here's some of
proposal
what
right
Mitch
now is
McConnell had
probably
to say.
from the left.
Here in the
Because
Senate,
if you're talking about
the president's
totally
lawyers will finally
replacing
receive a
all the
level
government
playing
welfare
field
and government subsidy
with the House
programs that
Democrats,
currently exist
and will
with
finally
one
be able to
program called
present the
UBI,
president's
which is the only
case.
reason the Republicans would ever support it.
Finally,
Because the whole point from the Republicans
some
is to
fairness.
like get rid of the government
on every
bureaucracy
point,
and make it
our
streamlined.
straightforward resolution
So
will
if
bring
your
the
proposal is
clarity
let's get rid of
and
all the current
fairness
programs in favor of this one
that everyone
program,
deserves.
I doubt you
President
get
of the United
many
States,
Democrat votes for it
House
because
of Representatives,
what Democrat is
and
going
the
to, for
American
example,
people.
vote to like end Social Security?
This is
You
the
know,
fair
or even make it
roadmap
like where you can grandfather in. I think you have a tough time actually
We need
getting
it in
left-leaning
place
votes.
before we can
Never
move
mind the
forward.
right-leaning votes. I think you have a tough time
So the
getting
Senate should
left-leaning
prepare
votes
to remain in session
for such
today
a
until
proposal
we
right now.
complete this resolution
That's my sense of it.
and adopt it.
Oh,
This
and of course
basic
you can attack it
four-part
from left, right,
structure
and
aligns
libertarian
with the
viewpoints,
first
of course.
steps
Absolutely true.
of the Clinton
So
impeachment
yeah,
trial
don't misunderstand
in
what I said
1999.
is like, you know, there's no
21 years ago,
evidence of
100
attack. You can
senators
attack it
agreed
all kinds of
unanimously
different
that
ways.
this roadmap was the
You can
right
attack it all
way
kinds of different ways.
to begin
So,
the trial.
yeah.
All 100 senators agreed the proper time to consider the question of potential witnesses was after opening arguments and senators' questions. Now, some outside voices have been urging the Senate to break with Preston on this question. Loud voices, including the leadership of the House majority,
Is this from earlier?
colluded with Senate Democrats
assuming
and
this
tried
is
to
from
force
earlier.
the Senate to pre-commit ourselves to seek specific
It says today. I'm
witnesses
assuming this happened earlier.
and documents
'cause they're in a
before
recess.
senators had even heard opening
What
arguments.
about people who can work? What about them?
Or even ask
Everyone gets the
questions.
UBI. Just everyone
These are
gets
potential
UBI.
witnesses,
That's
Mr. President, whom the
and
House
you're,
managers
because you're not
themselves-
disincentivized from working.
themselves declined to hear
You know,
from.
if everyone gets $1,000 a
House
month,
Itself declined
if you want
to
more
pursue
money, go
through the
earn
legal
it.
system
So that's nice.
during its own inquiry. The House was not facing any deadline.
Yeah, I
were
don't
free
really
to run
support
whatever
increasing the minimum
investigation
wage.
they wanted to
one
run.
of the nice things about UBI is it
If they
solves
wanted
all that problems,
witnesses
right? We don't really need a minimum wage
who would
anymore.
trigger legal battles
Presumably, you could
over
abolish the
presidential
minimum wage
privilege.
completely
could
because
have
you've
had
taken
those
care of the
fights.
problem on the other end. So you could theoretically
But the
abolish the
chairman
minimum
of the
wage
House Intelligence Committee and the chairman of the House
in
Judiciary
favor of a
Committee
UBI. The
decided
Republicans
not
would
to.
like that plan quite a lot.
They decided their inquiry was finished and moved right ahead. The House chose not to pursue the same witnesses they apparently would now like the Senate to pre-commit to pursuing ourselves.
Bye-bye, Newt.
As
Bye,
I've been
Newt.
saying for weeks, nobody will dictate Senate procedure to United States senators. A majority of us are committed to upholding the unanimous bipartisan Clinton precedent against outside influences.
People who can't work still get the $1,000 a month. So they have enough to take care of their basic needs.
questions.
And if they need more than
And
that,
so,
then they can.
if any amendments
then
are
there'll be
brought forward
private
to
groups,
force
but they have enough to
premature
take care of their
decisions
basic subsistence.
on mid-trial
So,
questions, I will move to
You know, but
table
that is
such
one of the
amendments
problems with
and
UBI
protect
is the
our
universal aspect of
bipartisan
it. So that's one of the
precedent.
big criticisms, right?
If a senator
The whole
moves to
point
amend the
is we're giving
resolution in
everyone
order to
exactly the
subpoena
same. If you
specific
start saying, well,
witnesses
what
or
about
documents,
what do you
I will
you say, well,
move
what
to
about
table
people who have
such
more
motions
children? What about
because the
people who
Senate
have
will
more
decide those
dependents?
questions
What about people who
later in the
have more
trial,
medical needs? What about
just
people
like
who
we
need this? What
did
about people who need that?
back in 1999.
Now, as soon as you start answering those kinds of
House
questions,
Majority
you've
Leader
just
Mitch McConnell earlier
created
on
a
the
system as
Senate
complicated
floor
as the one
talking
you're trying to
about
replace in the first
the
place,
effort he will make to
with a whole bunch of
table
rules and a
motions
whole
that
bunch of
ask
cutoffs for a whole bunch of
witnesses
conditions and blah, blah,
additional
blah.
documents, just
So,
what
like, as
happened
soon
a
as
short
you,
while
like,
ago
change
with,
the
Democratic
UBI
leader Chuck
for any
Schumer
of these
offering
needs,
the first
you've
of
kind
what
of
we
blown the
expect to
point.
be somewhat
So that
in
is
the
one of the
range
big
of 10,
criticisms
perhaps
of
15
UBI is the
amendments
fact that it's
throughout
universal.
the course of the impeachment
Is that it doesn't
day
attempt
one
to
here
account,
in the
it doesn't
US
want to
Senate.
account
Here's what
for any
NPR
need, it
reports
doesn't
on that
attempt to
First
account
Amendment
for
proposed by
anything. It just
Senator
gives
Chuck
everyone
Schumer.
exactly
The
the
minority
same.
leader offered an amendment to
Regardless
subpoena
of
the
need.
records
So
of
even if you have,
communications
you know,
related to
5
the
sick
White House
children,
officials,
3 of whom
National
are dying of
Security Council
cancer,
personnel,
and
other Trump
incredible medical
administration
bills, you get no
officials
more.
who have
If you say, well, we should give that
direct
person
knowledge of
more
key
because of their
events in
need,
question.
you have
when the
blown
Senate
entire
comes back,
point
and that may be in
immediately.
about
So that is a
10
criticism
minutes or
of
so. We don't
UBI.
expect this to be a long break. There could be a vote at that time. The majority leader saying he's going to make a motion to table or to block that effort by Leader Schumer in the Senate. We'll have live coverage, of course, when they gavel back in.
Yeah.
The lead manager in the House,
for me, as soon as you say,
Committee, Adam Schiff,
let's change it for X, I think the game is over.
Their desire to see additional witnesses.
I think as soon as you say, let's make it $1,200 a month for this person because of their need.
As a matter of history
I think the
and
game is
precedent,
over.
it would be wrong to assert
because as
that
soon
the
as you
Senate
do
is
that,
unable to obtain and review new evidence.
you're in a situation where now everyone is
regardless of
lobbying
why
for their
evidence
needs
was
and
not
how their
produced
special their needs
in the
are.
House.
And suddenly you've created
You
a
can
system
and
that's as
should
complicated and
insist
Byzantine
on
as the
receiving
system
all
you're
the
trying to
evidence
replace.
so you can render impartial justice.
The only way it works is if everyone
can
gets
earn
exactly
the
the same,
confidence of
regardless
the
of need,
public
regardless of whatever. Everyone
in
gets
the
the same
Senate's willingness
just
to
because
hold
they're a
a
citizen.
fair trial.
And so,
Under the Constitution,
if you can't,
the Senate
if
does
you
not
can't
just
do that,
vote on
then
impeachments.
or at least this
It does
Republican
not
won't
just
support it.
debate them.
You know,
Instead, it
if you're
is
going to start
commanded
saying,
by the
let's do this, but let's make
Constitution to
exceptions,
try
you're just asking to create a
all
system as
cases of
complicated as the one
impeachment.
you're trying to replace. So why bother?
If the founders intended for the House to try the matter and the Senate to consider an appeal based on the cold record from the other chamber, they would have said so. But they did not. Instead, they gave us the power to charge and you the power to try all impeachments. The framers chose their language and the structure for a reason.
$12,000 a year is
As
just
Alexander
below
Hamilton
poverty
said,
rate in the U.S., I
The
believe.
Senate is given awful discretion in matters
So you
of
should be
impeachment.
able to live
The Constitution
on
that speaks to
$12,000 a year. Now,
senators
obviously, you're not
in
going
their
to be able to
judicial
live
character
in
as a court
some places.
for the trial of
But there are definitely
impeachments.
places you could live on
It requires
$12,000 a
them
year.
to aim at real
It
demonstrations.
won't be easy, but it's
of
definitely
innocence
possible
or
and
guilt.
doable.
And it requires them to do so
You know, it
by
won't be
holding a
like the most
trial.
pleasant, lavish existence, but it's
The
subsistence.
Senate has repeatedly subpoenaed
enough to-
and
it's
received
enough
new
to
documents, often
keep
many
you
of them
living.
while adjudicating cases of impeachment. Moreover, the Senate has heard witness testimony in every one of the 15 Senate trials, full Senate trials in the history of this republic, including
I don't
those
think
for
you can adjust for
Presidents
cost
Andrew
of living,
Johnson
for
and Bill
example. I don't
Clinton.
think you can like give more people in New York
Indeed,
more
in
money for
President
cost
Andrew
of living
Johnson's
because
Senate
then that
impeachment
creates all
trial, the
kinds of
House
problems
managers
too.
were permitted
It has to be
begin
universal. It has to
presenting
be
documentary
everyone
evidence
gets
to
the
the
same, no
Senate
matter where
on
they
the
live, no
very
matter the cost of
first day
living,
of
no
the
matter the
trial.
cost of stuff. Everyone gets exactly
The
the
House
same.
manager's initial presentation of documents in President Johnson's case carried on for the first 2 days of trial, immediately after which witnesses were called to appear in the Senate. This has
UBI
been
is
the
meant to keep
standard
people from zero.
practice in prior
Yeah, that's what it's meant to do.
impeachment trials.
It's meant to keep
Indeed,
people from
in
absolute
most trials, this body has heard from many
absolute
witnesses,
depravity.
ranging from 3 in
It's
President
meant to keep
Clinton's
people
case
from absolute ruin.
to 40 in President
$1,000
Johnson's,
a month
and well over 60
enough to keep you
in
from
other
absolute ruin.
impeachments. As these numbers make clear, the Senate has
that's what it's meant
always
to do.
heard from key witnesses when trying an impeachment.
And if you can get a job
The notion
paying you
that only
$5
evidence
an
that is
hour
taken before the
on
House
top of that,
should be considered is squarely
you know,
and
that $5 an hour
unequivocally
suddenly becomes a lot more
contrary
valuable.
to Senate precedent.
you know,
Nothing in law
it's $5 an
or
hour
history
is
supports it.
$40
To
a
start,
day.
Consider
It's
Leader
$200
McConnell's
a
own
week.
description of his work in a prior
It's
Senate
$800 a
impeachment
month.
proceeding. After serving on the Senate Trial
You know,
Committee in the case of Judge
so-
Claiborne, Leader McConnell described how
Not
the
bad.
Senate committee, quote, labored intensively for more than 2 months, amassing the necessary evidence and testimony. In the same essay, Leader McConnell recognized
And of course,
the
Matt,
full
when you're
body's
talking about numbers
responsibility
that are
for
more
amassing
reasonable and less
digesting
reasonable, just
evidence.
remember what you're talking about doing. You're
There
talking
was certainly a lot
about
of
trying to
evidence for the
give this
Senate to
amount of
amass
money
and digest in
to
that
every
proceeding,
citizen over
which
the age
involved
of
charges
18.
against a district court
So,
judge. The Senate
let's
heard
try to figure out
testimony
how many
from
people that
19
is.
witnesses, and it allowed for over 2,000 pages of documents to be entered into the record over the course of that trial. At no point did the Senate limit evidence to what was before the House.
Yeah.
It did the opposite, consistent with unbroken
Let's
Senate
see.
practice in every single impeachment trial.
2010.
Every single one. For example, of the 40 witnesses who testified during President Johnson's Senate trial,
what's
only
Census Bureau
3
data?
provided testimony to the House during its impeachment inquiry. Only 3.
Let's
The
see.
remaining 37 witnesses
Persons
in that
under
presidential
18 is
impeachment trial
22.4%. So
testified
that means
before the
that
Senate.
77.6%.
Similarly, the Senate's full
All
first
right.
impeachment trial,
So
which
let's
involved
take this
charges
number
against
and
Judge
multiply
Pickering,
it by
involved testimony from 11 witnesses,
77.6%.
all of whom
Well, that's
were
total
new to the
persons, not
impeachment proceedings
citizens.
and had not testified before the House.
Um,
There are many other examples of this point, including the Senate's most recent impeachment trial,
Hold on.
of Judge Porteous in 2010.
Because the U.S. citizenship
It is one
doesn't
that
ask
many
about-
of you
yeah, they
and
don't ask
some of
about
us
citizenship status.
know well. It too is consistent with this long-standing practice. There, the Senate heard testimony from 26 witnesses, 17 of whom had not
Well, let's say it's
testified
200
before
million.
the House
That's just
during
a
its
rough
impeachment
number.
inquiry.
It's
Thus,
probably a
there
lot
is
more than
definitive
that, but let's say
tradition of the
200
Senate
million.
hearing from new witnesses.
So you want to
when
give 200
trying
million
articles
people-
of impeachment.
Whatever, and do the
There
math
has
on
never
how
been
you're
a
going to
rule
support
limiting witnesses
on that.
to those who appeared in the House or limiting evidence before the Senate to that which the House itself
331
considered.
sounds like the total population of the
And that
United
is
States,
because,
Matthew.
as Senator Hiram Johnson
Doesn't sound
explained
like
in
the number of
1934,
people
the
who are citizens
integrity of
over the age
Senate
of 18.
impeachment trials
We're not giving it to every
depend
person, we're
heavily
giving it to
upon
every
the
citizen.
witnesses
Remember,
who are
the whole-
called. Their
from
appearance
Yang's
on
point
the
of view, it's,
stand, their mode of giving
From
testimony.
Yang's point of view, it's a citizen benefit. So we're trying to figure out the
There
U.S.
is thus
citizen
an
population
unbroken history of
over the age
witness
18.
testimony in Senate impeachment trials. Presidential and judicial. I would argue in the case of a president, it is even more important to hear the witnesses and see the documents.
Now, Yang does have some interesting ideas on how to pay for
Any
some of it.
conceivable doubt on
Yeah.
this score, and there should
Jake
be
the
none
Hammer
left,
points
is
out the
dispelled by
value-added
Senate's
tax
own rules
is one way to
for
pay
trial of
for it. I
impeachment.
think the value-added tax is a really, really good
Obtaining
idea.
documents and hearing live witness
I really
testimony
like
is
it,
so
especially if
fundamental
you
that
want
the rules
to,
of procedure and practice in the Senate, when
especially
sitting
if
on
you want to get
impeachment
rid of
trials,
all current
which date
corporate
back
tax
to the 19th century,
and just
devote
use
more attention to the
VAT
gathering, handling,
instead.
and admission of
I
new
think
evidence
VAT is way
than
more
any other
efficient
single
and also
subject.
way more fair.
These
So I think
rules
that's a good idea.
expressly
If you want to get rid of the
contemplate that Senate will
corporate
hear
taxes and
evidence
just use
and
VAT
conduct a
instead.
thorough trial when
And
sitting as a
Yang
court of
also has an
impeachment.
idea of charging some
At
small
every turn, they
transaction
reject
fee
the notion that the
on
Senate
any sort
would
of
take
buy
the
or
House's
sell of any
evidentiary
stock.
record,
The
blind
idea
itself
being
to
that
everything else, and
the
vote to
bots that are
convict or
running, that are
acquit.
like running these trades
For example,
all
Rule
the time
6
in
says
the
the Senate
background
shall have the power
to
to
gain these little
compel
super
the
efficiencies.
attendance of
I mean, you
witnesses
could charge
and
like
enforce obedience to its
0.001% tax, and
Rule 7
there's so much
authorizes the
there that
presiding
you're
officer
getting
to
quite a
rule on
lot
all
of volume.
questions
So
of
that's one of
evidence,
his ways of
including but
getting
not limited
incumbents
to
from charging that,
questions
which I
of
think is also a
relevancy,
pretty good idea.
materiality, and redundancy. This rule, too, presumes that the Senate trial will have
So
testimony.
253,
giving
but presumably
rise to
that's
such
all people,
questions.
not just citizens.
Rule 11 authorizes
again,
the full
you'd have
Senate
to
to
figure out
designate a
citizens, so
committee of senators to
let's say
receive
200 million
evidence
is a
and
more
take
reasonable
testimony
number.
at such times and places as the committee may determine. As Rule 11 makes clear, the committee's report must be transmitted to the full Senate for final adjudication. But nothing herein, the rule states, shall prevent the Senate
Yeah,
from
253
sending
is
for
presumably
any
the
witness
entire population,
and
not just
hearing his
citizens.
testimony in
We are
open
not giving
Senate
this to not
or by
to
order of the
non-citizens.
Senate involving the entire trial in the open Senate. Here, too,
But yeah,
the
if
Senate's
if
operative
this is what it
impeachment
would
rules
take for me as a
expressly
conservative to
contemplate and
support it.
provide
It needs to be a
for
complete
subpoenaing
replacement
witnesses and hearing their testimony
for all the current
as
programs.
part
It needs to
of
be a
the
complete
Senate
replacement for
trial.
Social Security,
House
Medicare,
Impeachment
Medicaid,
Manager Adam Schiff,
and
part of
everything
his opening
else.
statement
Food
to the
stamps,
Senate trial of President
all the
Donald
things,
Trump
at least on the
earlier
federal
today.
level, has to be
The
a
Senate in
complete
a
replacement
recess.
for
They've
all
been
current
out
federal
for 10,
programs.
maybe 12 minutes or so.
So-
They should be gaveling back in shortly. When they return, they will take
No, Schiff
up
isn't talking. They're on
Senator
break. They're just
Schumer's
going back from
proposed
earlier.
amendment to allow
We've been talking about
additional
UBI quite a little
documents
bit about and the
testimony
advantages and
from White
disadvantages
House
of UBI.
officials. And that will happen shortly thereafter. When the Senate returns, we expect.
So I think
up to
Yang's idea is
2
pretty
hours
interesting,
debate
pretty promising.
on that amendment.
I think you have
at which
problems
time
getting
we
people to support
anticipate
it
that the
for the
Majority
reasons
Leader
I
Mitch
was saying,
McConnell
you
will
know.
make a motion to table, a motion to block that, and we could see some votes around that. While we wait for the Senate to come in, we
replacing
did
tax
want to show
write-offs,
you some of the
exactly.
opening statements earlier today from the White House counsel, Pat Cipollone.
Never before in the history of our country has a president been confronted with this kind of
I definitely don't
impeachment
want to do
proceeding in the
a system
House.
where I have UBI on top
It
of all
wasn't
the other
conducted
current
by the
programs in
Judiciary
place.
Committee.
That I definitely don't want
Now,
to do.
Mr.
That's just too
Nadler,
much.
when he
That's
applied for
too
that
much of a mess.
job, told his colleagues
If you want to do
when
UBI
they
as a
took
total
over the
replacement
House,
for the
that he
current
was
plan,
really
then
good at
I'm
impeachment.
on board.
But what happened was the proceedings took place in a basement of the House of Representatives. The president was forbidden from attending. The president was not allowed to have a lawyer present. In every other impeachment proceeding, the president has been given a minimal due process. Nothing here. Not even Mr. Schiff's Republican colleagues were allowed into the SCIF. Information was selectively leaked out. Witnesses were threatened.
Yeah, that the healthcare problems are
Good
there in
public
the world
servants
of
were told that they would be
issues
held
there,
in
but
contempt. They were told that
personally,
they were
I'd like to fix
obstructing.
healthcare
What
by
does Mr.
opening up a
Schiff
federal exchange.
mean by obstructing?
You know,
He
one of the
means
reasons that federal
unless
government
you do
employees have reasonably good
exactly what he
insurance is
says,
that there's such a big pool
regardless of your
because it's
constitutional
all federal
rights,
employees,
then you're obstructing.
and it's across all states, right? So, like,
The
I'd like to
president
replicate
was
that
not
for
allowed to
people
call
at
witnesses.
large. I'd like to have a system where
By the
people
way,
can buy private
There's
insurance,
still evidence in the SCIF
on a truly
that
national
we haven't
market.
been allowed to see.
and I think that would
wonder
be
why.
really good for everybody. It's good for the businesses because they have access to way more consumers, and it's good for the
witnesses.
consons because
let's
the economies
think
of
about
scale
something
mean
else
that
for a second.
the things
Let's
should be a
think
little
about
cheaper.
something else.
And of course, because it's
They
all
held
federal
these
program, the
articles
federal government can
for
regulate it and
33
set up
days.
rules
We
for
hear
how to
all this
participate. So they
talk
could say things like,
about an
in order to
overwhelming
participate
case.
in our exchange, you
An
have
overwhelming
to
case that they're
spend
not even
85% of
prepared
your
today
revenue
to stand
on
up
health
and make an
care
opening
directly
argument
to
about.
people, and you know, you get extra money
because
if
they
you
have
can
no
lower
case.
costs and make things cheaper.
Frankly,
and
they have
you
no
create all kinds of
charge.
incentives for them
When
to
you look at
to
these
race
articles
against each
of
other.
impeachment,
You know, you get an
they're
extra
not
percentage
only
of your income back,
ridiculous, they are
of your money
dangerous
back
to
if
our
you are the
republic.
best at
And
lowering
why?
prices for certain whatever.
First of all,
So
the notion that invoking your constitutional rights to protect the executive branch that's been done by
I don't think there's
just about every president
constitutional
since
problem
George Washington.
in
That is
doing
obstruction.
what I'm suggesting, because the Commerce
That is
Clause
our
should get you
patriotic
there.
duty,
I don't see
Mr.
a
Schiff,
problem
particularly when
with the
confronted
federal government preempting the health care
with
field.
a wholesale trampling of
I mean, in terms of
constitutional
legally.
rights that
We're talking
I'm
about. Now,
unfamiliar
there are all kinds
with
of practical or philosophical
in this
problems, but in
country.
terms of legally,
Frankly, it's
I
the
think it should
kind
be
of
fine.
thing that our State
The federal
Department
government
would
wanted to say,
criticize
well,
if
now
we see it in
we are
foreign
going to
countries.
preempt the field
We've never
for
seen
all
anything
health
like
care.
it. And Mr. Schiff
And
said,
now
have I got
all
a deal
health care
for
has
you?
to be run out of federal programs
Abandon all your
and sucks to be
constitutional
you.
rights.
I think that's legal. I don't see an obvious problem with it.
Forget about
Obamacare
your
didn't go that way,
lawyers.
but I don't see a legal impediment.
And come in and do exactly what I say. No, thank you. No, thank you. And then he says he has the temerity to come into the Senate and say, we have no use for courts. It's outrageous.
The Commerce Clause does
now,
cover
let me
kind
tell
of
you
everything.
another
Yes.
story.
The Commerce Clause, and this would qualify
There's
as
a
interstate
man
commerce, right?
named
I mean,
Charlie Kupperman.
this
He
is
the
interstate
deputy
commerce, right? It's
national
most decidedly
security
interstate. You've
advisor.
got a bunch of states
He is the number 2
and
to
all
John
doing
Bolton.
the similar thing and say, well, we're going to consolidate and
Because you have to
regulate to the
remember,
point of we're running the show.
Mr. Schiff wants you to forget, but
I think you
have
can
to
get there.
remember how we got
I think
here.
you can get there.
They threatened him. They sent him a subpoena.
Yeah, and A. Hedinger is right. It
Mr.
didn't create a
Kupperman did
national
what
exchange.
any American should be
That's
allowed
true.
to
It
do.
didn't. I'm saying
used
how
to
I
be
would
allowed
fix
to
it,
do.
not how Obamacare fixed it. This
He was forced
this is the Mueller Care Plan.
to get a lawyer.
So if you're interested in the Mueller Care
forced
Plan,
to
that's
pay
what
for that
Mueller has
lawyer.
for you. He has a national exchange.
And he
plan.
went to court. Mr. Schiff doesn't like courts. He went to court. And he said, Judge, tell me what to do. I have obligations that
And you don't
frankly
necessarily have to preempt the
rise
field
what
either.
the Supreme Court has called
Congress could
the
do it as part of its
apex
regulatory authority
of
and not preempt the
executive
field.
privilege in the area of national security.
So you could also allow
And then
state-level
I have a
insurance
subpoena
plans and stuff like that. You don't necessarily have to
Mr. Schiff.
preempt.
What do I do?
So either would be fine. Either take over the field
You know what
or
Mr. Schiff did?
administer your own plans through
Mr. Kupperman
whatever.
went to the judge, and the House said, never mind, we withdraw the subpoena. We promise not to issue it again. And then they come here and they ask you to do the work that they refuse to do for themselves. They ask you to trample on executive privilege. Now, would they ever suggest that the executive could determine on its own what the speech or debate clause means? Of course not. Would they ever suggest that the House could invade the discussions that the Supreme Court has behind closed doors? I hope not. But they come here and they ask you to do what they refuse to do for themselves. They had a court date.
Yeah, there may not be a practical difference in the end. You might be right. It might
And they
be so
withdrew the
advantageous
subpoena,
from the
they
economies of
evaded
scale
a
that the
decision,
states won't be
and
able
they're asking
to
you to
effectively
become
do it, because
complicit
who
in
would
that
want to
evasion
offer
of
a
the
state
courts.
plan?
It's
Who wants to sell
ridiculous.
to even 50
That is
million
White House
people in the
counsel
case of
Pat
California.
Cipollone, part of the
350
president's
million
team,
people.
the defense
Because of the
team
federal
in the
government.
impeachment trial, part
It's like,
of
I
his
just created a
opening
market
comments
for you. Do you want a
earlier
piece
this
of my
afternoon
market?
in the
It's like,
impeachment trial of President Trump.
pretty attractive.
They also heard from Jay Sekulow, Attorney Jay
Which
Sekulow.
means that if I'm the
and as
federal
we played
government
you there a while ago, Adam
and
Schiff,
I am
the chair
creating
of
this
the
new market
Intelligence
for you that
Committee
doesn't
and one of
exist, I'm like,
7
hey, healthcare
of the
companies.
House managers
You know
presenting
how,
the
like, even in the
impeachment
best case
articles
right now, you
in
can
the
sell to
U.S.
50
Senate.
million
The Senate
people if
is
you
in a
happen to be in
break. They've been out
California?
for just over
I
20
mean, that's nice
minutes
and all.
or so.
But how'd you like to be able to sell to 7 times more people
back
than that?
down, and
How'd you like to be able to sell to everyone?
deliberations. We anticipate that they will take
How would
up
you like? How would you like to have
amendment
that
proposed
big
by
pile
the
of
Democratic
revenue
leader, Chuck
and
Schumer,
that big market and
to,
have that big
to
pool of
allow more
insurance?
witnesses, to allow
Sound
more
pretty good, doesn't it?
documentary evidence.
Well, just convenient for you. I happen to have this plan right over here. All you have to do is abide by these rules, and you can sell to everybody.
What has changed a little bit is some
I
of
have
the
quite a bit of
rules
leverage
for
in this
the
situation
actual
if I'm the federal government.
deliberation of the impeachment
Oh, also, by the way, if you don't want to do
trial.
it, that's
Initially,
cool
they
because your
were going
competitors
to
will.
allow each side to
So,
have
you know, if you don't want to accept my
12
terms,
hours over
you know,
2 days.
someone
That's
else
now
will.
been spread out
So,
over 3 days.
no
Here was
problem.
the change noted by roll call. McConnell made 2 changes
I got a big
to
stick from the federal government in this
proposed
situation.
impeachment trial
I can
rules.
command quite
Each
a
side
lot
has
of
24 hours, to present
whatever
arguments
I
over
want to
3
in
days
this
rather
hypothetical.
than 2. Automatic introduction of House
So,
records into
gives
evidence
me a lot of
rather than
ability
a
to
vote
fix
needed to
things.
admit the records. Cameron Joseph with Vice News reports that following the discussion, a statement from
I think this
Mitch
impeachment
McConnell's
will
spokesman
take
saying,
2-3
following
weeks.
the discussion at today's lunch, Leader
my guess.
McConnell's organizing resolution had 2 modifications. Leanne Caldwell of NBC reporting some of the backstory on that, saying that Senator Collins, among others, played a role in the changes. Quote, Collins and others raised concern
I think it
about
will
the
take 2 to 3
24 hours
weeks,
of opening
and I think nothing's
statements
gonna happen.
in 2 days. So it's now over 3 days. And Scott Wong here, the handwritten changes to McConnell impeachment resolution, changing the 2-day limit on opening arguments to 3 days. Not a major change, but significant in the fact there will be more time, perhaps days that won't be quite as long. You can also read the proposed changes. We should have them up shortly. They've created a new document here, so it should be reflected in a document that you'll find among many others at cspan.org/impeachment. The president is in
Swarley,
Davos,
what'd you miss? You
Switzerland
missed
for the
opening
World
statements.
Economic Forum. He, however, has
How long will it take the
weighed
second
in
impeachment
on the
to make it
impeachment,
to the Senate
watching
after that?
perhaps some of the opening arguments this afternoon, and tweeting simply,
Well, I guess
read
all
the
depending.
transcript.
This is
Senator
all
Schumer
assuming
weighed in
that
saying,
Donald Trump
I
is going to
just
get
took to the
reelected,
floor
right?
to demand a vote to
So
subpoena
if Donald
the
Trump gets
witnesses
reelected, then
and documents needed for a fair trial. Will Senate Republicans vote for a fair trial?
I don't know.
Or will they enable
A year and a
cover-up?
half, maybe.
And again, when the Senate gavels back in,
Maybe a
what
year.
we expect will happen is debate will begin on Senator Schumer's amendment. Up to 2 hours of debate on that amendment. Then we understand the Majority Leader Mitch McConnell will make a motion to block it, what's called the motion to table, and we could see some votes around that time. I want to take a look at some of the managers that you'll see. You've seen Adam Schiff. Perhaps we'll see some of the other 6 managers on the floor that include the chair of the Judiciary Committee, Jerry Nadler, and Zoe Lofgren, who is the chair of the House Administration Committee. On the
Democrat senators who are
president's
campaigning
side,
are
the
missing out on
president's
key campaigning.
defense
Yeah,
team,
that's
you've
true.
already seen from 2 of his attorneys, Jay Sekulow, and opened up with the White House counsel, Pat Cipollone. Also, Ken Starr and Alan Dershowitz and Pam Bondi from Florida added to that team late last week. House Republicans are also represented in the chamber as well, including Doug Collins of the Judiciary Committee, Jim Jordan, who was very active, obviously, in the Intelligence Committee discussions and more. So it's possible we'll hear from some of those members presenting on the Senate floor as we wait for the Senate to return
I think
live
the
here
odds
on
of him
C-SPAN.
getting impeached again if he gets reelected are pretty high. Well, Ken Starr is the most experienced person in this by far, right? So he's the person you want. Dan asked,
Well,
does
somebody
does
please,
think
there
any
you
of the
go.
posturing will convince anyone?
I'd like to
No, I do
remind
not.
everybody to
I do not
take
think
your
it will
seats,
convince anyone.
and when the Chief Justice comes in, we really should all stand.
Stand for the Chief Justice? That's probably a good idea. They don't have the little buzzer that they have in the Supreme Court, though. They have a little buzzer on the Supreme Court when they're entering. Bzzzt.
May heard a bit of audio there. A reminder that audio and video comes from the Senate
courtroom
itself. We heard from the majority leader there, which sounds like they're getting ready to gavel back into session. So we won't go anywhere. We'll stay here live with further coverage of the impeachment trial of Donald Trump.
It was a pretty interesting discussion on UBI. We could have some more interpretation on Second Amendment stuff from yesterday's stream. There was some pushback in my comments already. Someone wants to give me a hard time about what the word arms means in the context of the Second Amendment. We could have more discussion about that. Yeah. I figure I'm going to give this about another 20 minutes, and then I'm going to stop. So we'll do 2 hours of streaming today, and then we'll pick up with some more later, maybe. So we got about 20 minutes of this, and then I'm going to give it a break. So if you want to talk about stuff for 20 minutes, let me know. Yeah. There is a certain civility to that. That's true, Eric. That is something to be grateful for, as opposed to how this would be handled in
obviously this is called the slate.
So that's
what
nice.
we see from the U.S. Senate, we're waiting for the Senate to come in. We heard some audio from the majority leader. We will have live coverage when they resume. While we wait for that, some of the
Senate
comments
will come to order. There are now 2 hours of argument on Senator Schumer's amendment.
Excuse me.
Mr. Schiff, do you wish to be heard on the amendment in proponent or as an opponent? Very well. Mr. Cipollone? Mr. Chief Justice, we are an opponent. Okay. Mr. Schiff, you have an hour.
Was Madison right about cannons on a merchant shipping arms? I don't know. I don't know what Madison said about that specifically enough, and I don't know about his underlying philosophy.
Thank you, Mr. Chief Justice. In a moment, I will introduce
and I'd also want to know
Manager
what did he mean,
California
in what
to
context
respond
did he
on
mean
the
it?
amendment.
What was the
But
question
I did want
that
to
was
take this
being asked
opportunity
specifically?
before
Because
certain
this gets into,
representations
again,
became
like, we have to be
congealed
precise about
to
what
respond
exactly
to
we're
my
talking
colleague's
about, because
argument on the
word
resolution at
arms
large.
might mean different things in
First,
different legal sections.
it's worth
or different
noting
things. So, for example,
they said nothing
someone
about the
was saying,
resolution.
Brought out ITAR.
They said nothing about the
To
resolution.
say something is an arm within the
They
meaning
made
of
no
ITAR does
effort
not
to
necessarily
defend
mean it's an
it.
arm within the meaning
They
of the
made
Second
no
Amendment
effort
and
to
vice versa.
even claim
So
that
I'd have
this
to
was
know
like the
more
Senate
about what he
trial
was
in
saying,
the
and
Clinton
I'd have to know
proceeding.
more
They
about
made
what he
no
was referring
argument
to
that,
specifically
well,
in order to
this is
answer that
different
question.
here because of this or that, or they made no
So,
argument about that whatsoever.
That's my first thought that comes to
They
that.
made no argument that it makes sense to try the case and then consider documents. They made no argument about why it makes sense to have
Can I
a
give
trial
you a
without
short
witnesses.
catch-up? Sure.
And why? Because it's indefensible.
We are starting the
It's
Trump
indefensible.
impeachment hearing.
No trial in America has ever been conducted like
in
that.
day one.
And so you heard
President
nothing
John
about
Roberts. Wow. He's not
And
president.
that should
Let
be
me
the
try that
most
again.
telling thing about
Chief
counsel's
Justice John
argument.
Roberts
They had
is
no
presiding
defense
in the Senate because, of course, he's
of
got
the
nothing
McConnell
better to do
resolution
with his
because
time.
there is none. They couldn't defend it on the basis of Senate
And
precedent.
we are
They
in
couldn't
opening
defend it
statements.
on the basis of
So we heard from Adam
Senate
Schiff earlier and
history.
from the
Traditionally
President's
couldn't defend it on the
Counsel,
basis
and
of the
now I guess we're hearing from
Constitution. They
Adam
couldn't
Schiff
defend
some
it
more.
at all. And so what
super
did they say?
exciting.
Well, first they made the representation that the House is claiming there is no such thing as executive privilege.
I'd have
That's
to,
nonsense.
I'd have to read the quote and consider
No one
it a
here
little
has
bit
ever
more
suggested there's no such thing as executive privilege.
in terms of what
but
he
the interesting
meant. Did he
thing
mean
here
within the
is
context of the Second Amendment.
they've never claimed
is the
executive
question.
privilege.
Because
Not once
I don't know what he
during the
meant
House
by it.
investigation did they ever say that a single document was privileged or a single witness had
If he
something
said
privileged
that,
to
if
say.
he said that they were arms,
And
what did
why
he mean
didn't they
by
invoke
arms?
privilege?
Did he mean
Why
it within
only
the meaning of
now?
the Second
And
Amendment,
even now they haven't
or did
quite
he mean it
invoked
in
it.
some other
Why
meaning?
only now? Why not in the House?
Is the next question that comes
Because
to
in
mind.
order to claim privilege, as they know, because they're good lawyers,
What if
you
Roberts
have
thought
to
he'd ever be here when
specify
he's clerking for the
which
last Chief
document,
Justice?
which
Good
line,
question.
which conversation, and they didn't want to do that because to do that, the president would have to reveal the evidence of his guilt.
Was
That's
Roberts a
why
clerk?
they made no invocation of privilege.
I was under the impression that
Now, they make the further argument that the House should
Gorsuch was the first one
only be able to impeach after
was a
they
clerk
exhaust
previously.
all
Was
legal
Roberts a clerk?
remedies.
For the Chief Justice?
As if the Constitution says the House shall have the sole power of impeachment, asterisk. but only after it goes to court, in the district court, then the Court of Appeals, and then en banc, and then the Supreme Court, and it's remanded, and they go back up the chain, and it takes years. Why didn't the founders require the exhaustion of legal remedies? Because they didn't want to put the impeachment process in the courts. And you know, what's interesting is that while these lawyers for the president are here before you today saying the House should have gone to court, they are in court saying the House may not go to court to enforce its subpoenas. I kid you not. Other lawyers, maybe not the ones at this table, but other lawyers for the president, are in court saying the exact opposite of what they're telling you today. They're saying you cannot enforce congressional subpoenas. That's non-judiciable.
In court
you can't do it.
Is saying, well, you don't have power
Counsel
to hear
brings up the case involving Charles Kupperman, who was a deputy to John Bolton on the National Security Council, and says he did what he should do. He went to court to fight us. Well, the Justice Department took the position he can't do that. So these lawyers are saying he should, and those lawyers are saying he shouldn't.
He was a clerk for Rehnquist while he was still an associate justice.
Ways. Now, interestingly,
okay, cool.
Well, Mr. Kupperman, Dr. Kupperman went to court,
and
they applaud him for doing that. His boss,
which is
John
also
Bolton,
interesting because at that point
no
in
Rehnquist's
career, Rehnquist was a lot more conservative when he was associate justice. We saw that in previous graphs too.
To you.
So it'd be interesting to know
He's willing to
how
come
much
and
that
testify and
influenced
tell
him
you
when
what he knows.
clerking
The question is, do you want to hear
for
it?
a much more conservative Rehnquist.
Do you want to hear it? Do you want to hear from someone who was in the meetings, someone who described what the president did, this deal between Mulvaney and Sondland as a drug deal? Do you want to know why it was a drug deal? Do you want to ask him why it was a drug deal? Do you want to ask him why he repeatedly told people, go talk to the lawyers? You should want to know. They don't want you to know. They don't want you to know. The president doesn't want you to know. Can you really live up to the oath you've taken to be impartial and not know? I don't think you can. Now, they also made the argument that you'll hear more later on from apparently Professor Dershowitz that, well, abuse of power is not an impeachable offense. It's interesting that they had to go outside the realm of constitutional lawyers and scholars to a criminal defense lawyer to make that argument because no reputable constitutional law expert would do that. Indeed, the one they called in the House, the Republicans called in the House, Jonathan Turley, has said exactly the opposite. There's a reason that Jonathan Turley is not sitting at the table, much to his dismay, and that is because he doesn't support their argument. So they'll cite him for one thing, but they'll ignore him for the other. Now they say, oh, the president is very transparent. He may have refused every subpoena, every document request, but he released 2 documents. The document on the July 25th call and the document on the April 21st call. Well, let's face it. He was forced to release the record of the July 25th call when he got caught. When a whistleblower filed a complaint, when we opened an investigation, he was forced because he got caught.
All right, I'm going to take a
you
very
don't
brief
get credit
break
for transparency when you get caught. And what's more, what's revealed in that, of course, is damning. Now they point to the only other record he has apparently released, the April 21st call, and that's interesting too. Now that's just a congratulatory call. But what's interesting about it is the president was urged on that call to bring up the issue of corruption. And indeed, in the readout of that call, the White House misleadingly said he did. But now that we've seen the record, we see that he didn't. And notwithstanding counsel's claim in their trial brief that the president raised the issue of corruption in his phone call, the July 25th call, of course, that word doesn't appear in either conversation. And why? Because the only corruption he cared about was the corruption that he could help bring about. Now, Mr. Cipollone made the representation that Republicans were not even allowed in the depositions conducted in the House. Now, I'm not going to suggest to you that Mr. Cipollone would deliberately make a false statement. I will leave it to Mr. Cipollone to make those allegations against others. But I will tell you this, he's mistaken. He's mistaken. Every Republican on the 3 investigative committees was allowed to participate in the depositions, and more than that, they got the same time we did. You show me another proceeding, another presidential impeachment or other that had that kind of access for the opposite party. Now, there were depositions in the Clinton impeachment. There were depositions in the Nixon impeachment. So what they would say is some secret process. Well, they were the same private depositions in these other impeachments as well. Finally, a couple last points. They make the argument the president was not allowed in the Judiciary Committee, chaired by my colleague, Chairman Nadler, to be present, to present evidence, to have his counsel present. That is also just plain wrong. Just plain wrong. Not going to suggest to you they're being deliberately misleading here, but it is just plain wrong. You've also heard my friends at the other table make attacks on me and Chairman Adler. You'll hear more of that. I'm not going to do them the dignity of responding to them, but I will say this. They make a very important point, although it's not the point I think they're trying to make. When you hear them attack the House managers, what you're really hearing is, we don't want to talk about the president's guilt. We don't want to talk about the McConnell resolution and how patently unfair it is. We don't want to talk about how pardon the expression, ass backwards it is to have a trial and then ask for witnesses. And so we'll attack the House managers because maybe we can distract you for a moment from what's before you. Maybe if we attack the House managers, you'll be thinking about them instead of thinking about the guilt of the president. So you'll hear more of that, and every time you do, every time you hear them attacking the House managers, I want you to ask yourselves, away from what issue are they trying to distract me? What was the issue that came up just before this? What are they trying to deflect my attention from? Why don't they have a better argument to make on the merits? Finally, Mr. Sekulow asks, why are we here? Why are we here? Well, I'll tell you why we're here. Because the president used the power of his office to coerce an ally at war with an adversary, at war with Russia, use the power of his office to withhold hundreds of millions of dollars of military aid that you appropriated and we appropriated to defend an ally and defend ourselves because it's our national security as well. And why? To fight corruption? That's nonsense, and you know it. He withheld that money, and he withheld even meeting with him in the Oval Office, the president of Ukraine, because he wanted to coerce Ukraine into these sham investigations of his opponent that he was terrified would beat him in the next election. That's what this is about. You want to say that's okay? Their brief says that's okay. The president has a right to do it. On Article 2, we heard the president, he can do whatever he wants. You want to say that's okay? Then you got to say that every future president can come into office and they can do the same thing. Are we prepared to say that? Well, that's why we're here. I now yield to Representative Lofgren.
Mr. Chief Justice, Senators, Counsel for the President, the House managers strongly support Senator Schumer's amendment, which would ensure a fair, legitimate trial based on a full evidentiary record. The Senate can remedy President Trump's unprecedented cover-up by taking a straightforward step. It can ask for the key evidence that the president has improperly blocked. Senator Schumer's amendment does just that. The amendment authorizes a subpoena for White House documents that are directly relevant to this case. These documents focus on the president's scheme to strong-arm Ukraine, to announce an investigation into his political opponent, to interfere with the 2020 election. The documents will reveal the extent of the White House's coordination with the president's agents, such as Ambassador Sondland and Rudy Giuliani, who pushed the president's so-called drug deal on Ukrainian officials. The documents will also show us how key players inside the White House, such as the president's acting chief of staff, Mick Mulvaney, and his deputy, Robert Blair, helped set up the deal by executing the freeze on all military aid and withholding a promised visit to the White House. The documents include records of the people who may have objected to this scheme, such as Ambassador Bolton. This is an important impeachment case against the president. The most important documents are going to be at the White House. The documents Senator Schumer's amendment targets would provide more clarity and context about President Trump's scheme. The amendment prevents the president from hiding evidence, as he has previously tried to do. Now, the House subpoenaed these documents as part of the impeachment inquiry, but the president completely rejected this and every document subpoena from the House. As powerful as our evidence is, and make no mistake, it overwhelmingly proves his guilt, we did not receive a single document from the executive branch agency, including the White House itself. Recent revelations from press reports, Freedom of Information Act requests, and additional witnesses, such as Lev Parnas, underscore how relevant these documents and therefore why the president has been so desperate to hide them and his misconduct from Congress and from the American people. A trial without all the relevant evidence is not a fair trial. It would be wrong for you senators acting as judges to be deprived of relevant evidence of the president's offenses when you are judging these most serious charges. It would also be unfair to the American people, who overwhelmingly believe the president should produce all relevant documents and evidence. Now, documentary evidence is used in all trials for a simple reason. As the story goes, the documents don't lie. Documents give objective, real-time insight into the events under investigation. The need for such evidence is especially important in Senate impeachment trials. More than 200 years of Senate practice make clear that documents are generally the first order of business. They've been presented to the Senate before witnesses take the stand in great volume to ensure the Senate has the evidence it needs to evaluate the case. Now, documentary evidence in Senate trials has never been limited to the documents sent by the House. The Senate, throughout its existence, has exercised its authority pursuant to its clear rules of procedure to subpoena documents at the outset of a trial. We don't know with certainty what the documents will say. We simply want the truth, whatever that truth may be. So do the American people. They want to know the truth, and so should everybody in this chamber, regardless of our party affiliation. There are key reasons why this amendment is necessary. We'll begin by walking through the history and precedent of Senate impeachment trials. I'll let you know about the House's efforts to get the documents, which were met by the president and his administration's categorical commitment to hide all the evidence at all costs. And we'll address the specific need for these subpoenaed White House documents. I'll tell you why these documents are needed now, not at the end of the trial, in order to ensure a full, fair trial based on a complete evidentiary record. Now, some have suggested incorrectly that the Senate is limited only to evidence gathered before the House approved its articles of impeachment. Others have suggested, also incorrectly, that it would somehow be strange for the Senate to issue subpoenas. These claims are without any historical, precedential, or legal support. Over the past 2 centuries, the Senate has always understood that its sole power under the Constitution to try all impeachments requires the Senate to sit as a court of impeachment and hold a trial. In fact, the founders assigned sole authority only twice in the Constitution. First, giving the House sole authority to impeach, and second, giving the Senate sole authority to try that impeachment. If the founders had intended for the Senate to serve as some kind of appellate body, they would have said that. But no, instead they wrote this. Article 1, Section 3, the Senate shall have the sole power to try all impeachments. The Senate has always received the relevant documents in impeachment trials, and indeed, the Senate's own rules of procedure and practice make clear that new evidence will be considered. Precedent shows this. All 15 full Senate impeachment trials considered new evidence. Let's look at a few examples that show the Senate takes new evidence in impeachment trials. The first ever presidential impeachment trial in 1868 against President Andrew Johnson allowed the House managers to spend the first 2 days of the trial introducing new documentary evidence. It was the same in Judge John Pickering's trial in 1804. New documents were presented to the Senate nearly a week before House managers made their opening statement and later throughout the trial. And, as been mentioned earlier by Mr. Schiff, in modern times, in 2010, George Porteous's impeachment trial included 7 months of pretrial discovery and 6,000 pages of documentary evidence admitted at trial. After that evidence was admitted, the Senate held its trial. President Clinton's case did not involve subpoenas for documents. Now, why was that? Because President Clinton had already produced a huge trove of documents. The independent counsel turned over to Congress some 90,000 pages of relevant documents gathered during the course of his years-long investigation. And I remember, as a member of the Judiciary Committee, going over to the Ford building, looking at the boxes of the document. But even with all those documents, the Clinton trial included the opportunity to present new evidence and the admission of additional documents and 3 witnesses. The Clinton impeachment precedent also shows how President Trump's refusal to produce any relevant documents in response to congressional subpoenas is different than past presidents, different from President Clinton, different from President Johnson, and less even than President Nixon. In short, not a single president has categorically refused to cooperate with an impeachment investigation. Not a single president has issued a blanket direction to his administration to produce no documents and no witnesses. These are the precedents the Senate must rely on. The Senate should issue a subpoena for documents at the very outset of the proceedings so that this body, the House managers, the president, can all account for those documents in their presentations and deliberations. It doesn't make sense to request and receive documents.
Why did the House not appoint an independent counsel? You mean in order to present? Because that's just not how it works according to the Constitution. Well, I don't know if it's actually according to the Constitution, but it's just not the way it's ever been done.
Continuing his categorical commitment to hide the evidence. In this case, the House sought White House documents. Why don't we have them? It's not because we didn't try. It's because the White House refused to give them to us. The president's defense team seems to believe that the White House is permitted to completely refuse to provide any documents without regard to whether or not it is privileged. They apparently believe that Congress's authority is subject to the approval of the president. Sure that no one, and certainly not the president, is above the law. Now, even President Nixon produced more than 30 transcripts of White House recordings and notes from meetings with the president. Here, even before the House launched the investigation that led to this trial, President Trump rejected Congress's constitutional responsibility to use its lawful authority to investigate his actions. He asserted that his administration was fighting all the subpoenas, proclaiming, "I have an Article 2, where I have the right to do whatever I want as president." Here is what he said.
Then I have an Article 2, where I have the right to do whatever I want as president.
Even after the House formally announced its investigation of the president's conduct in Ukraine, the president still continued his obstruction. Beginning on September 9th, 2019, the House Investigative Committee
I was just looking up the law on the copyright policy, but I'll get back to you on that issue.
stating the president's position that the President Trump and his administration cannot participate in this partisan inquiry under these circumstances. The president simply declared that he will not participate in an investigation he didn't like. 10 days later, on October 18th, the White House counsel sent a letter to the House confirming that it would continue to stonewall. The White House counsel again stated the president
I'm taking the
refused
position
to
as all public
participate.
domain.
Well, the Constitution, Article 1, Section 2, says that the House shall have the sole power of impeachment, just as in Article 1, Section 3, the Senate has the sole power to try. Participation in a duly authorized congressional investigation isn't optional. It's not up to the president to decide whether to participate or not. The Constitution gives the House the sole power of impeachment. It gives the Senate the sole power to try all impeachments. The president may not like being impeached, but if it's the
I think
president,
anything on the
not
floor counts as public hearing is my understanding, and my quick Googling seems to confirm.
When impeachment proceedings are
anything that's
appropriate,
floor debate is
then
public.
the impeachment power is no power at all.
So floor debates are in public,
And if
so
you
I
let
don't think
him
there's a copyright
block
interest
from
here.
Congress
So I
and
think I'm
from
in the
the
clear
American
for
people,
copyright.
the evidence to cover up his offenses, then the impeachment power truly will be meaningless. With all the back and forth about these documents, we've heard the phrase executive privilege. The president and his lawyers keep saying it. They talk about vast legal rights to justify hiding the truth, withholding information, but that's a distraction. That's not what the Constitution provides, and the truth is, as has been mentioned by Mr. Schiff, in the course of the entire impeachment inquiry, President Trump has not once asserted executive privilege, not a single time. It was not the reason provided by Mr. Cipollini for refusing to comply with the House's subpoena. Indeed, President Trump didn't offer legal justification for withholding the evidence. Here's the truth. Presidents, members of Congress, judges, and the Supreme Court have recognized throughout our nation's history that Congress's investigative power are at their absolute peak during impeachment proceedings. Your powers. Executive privilege cannot be a barrier to give absolute secrecy to cover up wrongdoing. If it did, the House and the Senate would see their power disappear. When President Nixon tried that argument by refusing to produce tape recordings to prosecutors and to Congress, he was soundly rebuked by the other two branches of government. The Supreme Court unanimously ruled against him. The House Judiciary Committee voted that he be impeached for obstruction of Congress. It would be remarkable for the United States Senate to declare, for the first time in our nation's history, that the president has an absolute right to decide whether his own impeachment trial is legitimate. And it would be extraordinary for the Senate to refuse to seek important documentary evidence, especially when the president has yet to assert any privilege to justify withholding documents. Now, there's another reason this amendment is important. The documents sought are directly relevant to the president's misconduct. The White House is concealing documents involving officials
it'll do for
who
today.
have
If C-SPAN wants to
direct
come after me,
knowledge
I
of
guess
key
they can come
events
after me.
at the heart of this trial. This isn't just a guess. We know these documents exist from the witnesses who testified in the House and from other public release of documents. And let's walk through those specific documents that the White House should send to the Senate. They include, among other documents, relating to President Trump's direct communications with President Zelensky, President Trump's request for political investigations, including communications with Rudy Giuliani, Ambassador Sondland, and others, President Trump's unlawful hold of the $391
Baba is you in the
million
background
of
too.
military aid,
I wonder if I can
concerns that
get
White
it on
House
screen,
officials reported to
two things on screen at the
NSC
same
legal
time.
counsel in
So
real
we can
time,
do
the
hearings
president's
and Baba is
decision
you
to
at the same
recall
time.
Ambassador Marie Yovanovitch from Ukraine. The first set of documents the Senate should get about President Trump's communication with the president of Ukraine. would include the phone calls on April 21st and July 25th.
Should we see if we can get Baba
as
Issue on screen at the exact same time that we're listening to this?
2019 meeting with President Zelensky in New York. We know, for example, that NSC officials prepared talking points for the president in preparation for both calls with the Ukrainian president. The talking points were about American policy as reflected by the votes of Congress as well as the Trump administration itself. They didn't include any mention of the Bidens or the 2016 election interference or investigations that President Trump requested on the July 25th call. Here's a clip of Lieutenant Colonel Vindman explaining how the president ignored the points about American policy, reflecting the views of both the Congress and the Trump administration.
Colonel Vindman, if I could turn your attention to the April 21st call, that is the first call between President Trump and President Zelensky. Did you prepare talking points for the president to use during that call?
Yes, I did.
And did those talking points include
rooting out corruption in Ukraine?
Impeachment?
Yes.
That was something the president was supposed to raise in the conversation with President Zelensky.
As we're listening to Baba Issue.
Those were the recommended talking points that were cleared through the NSC staff for the president, yes.
The materials provided for the July 25th call that Lieutenant Colonel Vindman mentioned are highly relevant. They could help confirm that the president's actual statements to President Zelensky were unrelated to the foreign policy objectives of his own administration and show that they served his own personal interests at the expense of America's
we'll learn a lot more from Baba Issue than we will
interests.
from the impeachment hearing, right?
These documents also include handwritten notes and other documents that White House officials generated.
Well, if I get a content ID strike, if only I knew a copyright lawyer who could help me, right?
Lieutenant Colonel Vindman, Mr.
Only
Morrison,
I knew a
Jennifer
copyright
Williams,
person.
all testified to taking contemporaneous handwritten notes during the July 25th call. Ms. Williams and Lieutenant Colonel Vindman both testified that President Zelensky made an explicit reference to Burisma that was not included in the memorandum that the White House released to the public. Here's a clip of their testimony.
Both of you recall President Zelensky in that conversation raising the issue or mentioning Burisma, do you not?
That's correct.
Correct.
And yet the word Burisma appears nowhere in the call record that's been released to the public, is that right?
That's right.
Correct.
Why do you need documents generated after the calls and meetings? They would shed light on how these events were perceived in the White House and what actions were taken moving forward. For example, National Security Advisor John Bolton wasn't on the 25th call, but he was apparently informed about the contents of the call afterward. His reaction, once he was informed, would be helpful to understanding the extent to which President Trump's action deviated from American policy and American security interests. There's another set of documents that the Senate should get, and they relate to the political investigations that President Trump and his agents repeatedly asked Ukrainian officials to announce. These documents about efforts to pressure Ukraine to announce investigations and the decision to place a hold on military aid to Ukraine, they would be very important for you to evaluate the president's conduct. For example, Ambassador Bolton is a first-hand witness to President Trump's abuse of power. He reported directly to the president. He supervised the entire staff of the National Security Council. Public reports indicate that John Bolton is a voracious note-taker in every meeting. From witness testimony, we know that Ambassador Bolton hosted the July 10th, 2019 meeting where Ambassador Sondland told Ukrainian officials that the promised White House meeting would be scheduled if they announced the investigations. We know Bolton was briefed about this meeting immediately following it when Ambassador Sondland said he had a deal with Mick Mulvaney to schedule the promised White House meeting if Ukraine announced investigations into the Bidens in the 2016 election. presidential decision memorandum in August, reflecting the consensus interagency opinion that Ukrainian security assistance was vital to America's national security, something that Congress had approved, appropriated, something the president had signed. Press reports indicate that he too was involved in a late August Oval Office meeting where he, Secretary Pompeo, and Secretary Esper all tried to convince the president to release the aid. Now, Ambassador Bolton has come forward and publicly confirmed that he was a witness to important events, but also that he has new evidence that no one has seen yet. If we know there's evidence that's not yet come out, all of us should want to hear it. We should want to hear it now. Before Ambassador Bolton testifies, we should get documents and records relating to his testimony, including his notes, which would provide contemporaneous evidence about what was discussed in meetings related to Ukraine, which would help to evaluate his testimony. The evidence is not just restricted to Ambassador Bolton. During his public testimony, Ambassador Gordon Sondland stated, "I have not had access to all my phone records." He also said that he and his lawyers had asked repeatedly for these materials. He said the materials would help refresh his memory. We should look at that material. Ambassador Sondland also testified that he exchanged a number of emails with top officials like Mick Mulvaney about his efforts to pressure Ukraine to announce the investigations President Trump demanded. Here's his testimony.
Third, let me say, precisely because we did not think that we were engaging in improper behavior, we made every effort to ensure that the relevant decision makers at the National Security Council and the State Department knew the important details of our efforts. The suggestion that we were engaged in some irregular or rogue diplomacy is absolutely false. I have now identified certain State Department emails and messages that provide contemporaneous support for my view. These emails show that the leadership of the State Department, the National Security Council, and the White House were all informed about the Ukraine efforts from May 23rd, 2019 until the security aid was released on September 11th, 2019.
These emails, among others, are in the possession of
precise.
These emails referenced in this testimony are in the possession of the White House, the State Department, and even the Department of Energy, since officials from all three entities communicated together. You know, during his testimony, Ambassador Sondland described it this way. Everyone was in the loop. It was no secret. These emails are therefore important to understanding the full scope of the scheme. The request for relevant evidence is not confined to Trump administration officials. The Senate should also get White House records relating to the president's private agents who acted on his behalf in Ukraine, including Rudy Giuliani, Victoria Tensing, and Joe DeGenova. Witness testimony and documents have made clear that Mr. Giuliani, a frequent visitor to the White House who also received and made frequent calls to the White House, was acting on behalf of the president to press Ukrainian officials to announce investigations that would personally and politically benefit the president. For example, the May 10th, 2019 letter from Mr. Giuliani to President-elect Zelensky, that's shown on this slide, states he was acting, quote, as personal counsel to President Trump with his knowledge and consent. He requested a meeting with the president-elect and he to be joined by Ms. Tensing, who was, quote, very familiar.
I can't figure out where to put you in
The evidence indicates he was collaborating with Ms. Tensing and Mr. Geneva in this effort. The Senate should get the White House records of meetings, calls involving Mr. Giuliani, Ms. Tensing, or Mr.
Win and Babbitt is you.
These records are important to help you understand the extent to which
if I coming from below, I can
The White House was involved in Mr. Giuliani's efforts to coerce Ukraine to announce the investigations the president wanted. The records would also show how the president's personal political agenda became more important than policies to help America's national security interests. The President's Counsel may, consistent with his prior attempts to hide evidence, assert that attorney-client privilege would cover these documents. But the President's personal attorney-client privilege cannot shield evidence of misconduct in office, or that of his aides, or of his lawyers' participation in corrupt schemes. We aren't asking for documents reflecting legitimate legal advice. You need documents about their actions to pressure Ukraine to announce an investigation into President Trump's political opponent. There's a set of White House documents that relate directly to the president's unlawful decision to withhold $391 million appropriated bipartisan to help Ukraine. Witnesses have testified that President Trump directly ordered a hold on the security assistance despite the unanimous opinion of his agencies that the aid should be released. Importantly,
You like Black News Boys? Thanks, I'm glad that you like it, yes.
His action violated the law. On January 16, 2020, the GAO, an independent watchdog, issued a legal opinion finding that President Trump violated the law when he held up security assistance to Ukraine. The GAO said, and I quote, "Faithful execution of the law does not permit the president to substitute his own policy priorities for those that Congress enacted into law. OMB withheld funds for a policy reason which is not permitted under the Impeachment Control Act. The withholding was not a programmatic delay. Therefore, we conclude that OMB violated the ICA. The fact that the president's action to freeze the aid, which he used to pressure Ukraine to announce the political investigations he wanted, was against not only the official consensus of his own administration, but also against the law, and it was to help himself.
Glad the volume's
That helps demonstrate these actions were taken for President Trump's personal and political benefit. Witness testimony and public reporting make clear the White House has a significant body of documents that relate to these key aspects of the president's scheme. Some of these documents outline the planning of the president's freeze. For example, the New York Times reported in June that Mr. Mulvaney emailed his senior advisor, Mr. Blair, "Did we ever find out about the money for Ukraine and whether we can hold it back?" This shows that Mr. Mulvaney was in email contact with his aides about the very issues under investigation as part of this impeachment. It tells us that the White House is in possession of communications that go to the heart of the charges before you. The Senate should also get materials prepared for summary notes from a late August meeting with President Trump, Secretary of Defense Mark Esper, and Secretary of State Mike Pompeo when they tried to convince the president that freeing, and this is a quote, "freeing up the money for Ukraine was the right thing to do." According to the New York Times, Ambassador Bolton told the president, "This is in America's interest." The Senate should review that highly relevant document, which reflects real-time assertions by President Trump's own senior aides that Ukrainian aid was in the national security interest of the United States and that there was no legitimate reason to hold up the aid. There are documents that include after-the-fact justifications to try and overcome legal problems and the unanimous objections to freezing assistance to Ukraine, and we know these documents exist. For example, on January 3rd, 2020, OMB stated in a letter to the New York Times that it had discovered 20 responsive documents consisting of 40 pages, reflecting emails between White White House official Robert Blair and OMB official Michael Duffy that relate directly to the freezing of the Ukraine security assistance. But OMB wouldn't release them in a Freedom of Information lawsuit, and they have refused to produce these documents at the direction of the president in response to the House's lawful subpoena. Now, the Washington Post reported that a confidential White House review of President Trump's decision to hold up hundreds of documents that reveal extensive efforts to generate an after-the-fact justification for the debate over whether the delay was legal. That's known as a cover-up, actually. The White House lawyers had apparently uncovered, quote, early August email exchanges between acting Chief of Staff Mick Mulvaney and White House budget officials seeking to provide some explanation for withholding the funds the president had already ordered on hold. The documents also reportedly include communications between White House officials and outside agencies. Not only does Congress have a right to see them, the public does too, under Freedom of Information laws. Now, as a matter of constitutional authority, the Senate has the greatest interest in and right to compel those documents. Indeed, as the news article explains, White House lawyers are reportedly, quote, worried about unflattering exchanges and facts that could, at a minimum, embarrass the president. Perhaps they should be worried about that. But the risk of embarrassment cannot outweigh the constitutional interests in this impeachment proceeding. Any evidence of guilt, including further proof of the real reason the president ordered the funds withheld, or after-the-fact attempts to paper over knowingly unlawful conduct, they must be provided to ensure a full and fair trial. No privilege or national security rationale can be used as a shield from disclosing misconduct. There are key White House documents relating to multiple instances when White House officials reported their concerns to White House lawyers about the president's scheme to press Ukraine to do the president a domestic political favor. For example, Lieutenant Colonel Vindman and Dr. Hill both informed NSC lawyers about the July 10th meeting in which Ambassador Sondland revealed he had a deal with Mr. Mulvaney. I'm going to go directly to the clip by Dr. Hill, because Dr. Hill, pardon me, at Bolton's direction, also reported that meeting to to John Eisenberg, as she explained in her testimony.
I had a discussion with Ambassador Bolton both after the meeting in his office, a very brief one, and then one immediately afterwards, the subsequent meeting.
So the subsequent meeting, or after both meetings, when you spoke to him and relayed to him what Ambassador Sondland said, what did Ambassador Bolton say to you?
Well, I just want to highlight, first of all, that Ambassador Bolton wanted me to hold back in the room immediately after the meeting. Again, I was sitting on the sofa with a colleague.
Right, but just in that second meeting, what did he say?
Yes, but he was making a very strong point. He wanted to know exactly what was being said. And when I came back and related it to him, he had some very specific instruction for me. And I'm presuming that that's...
what was that specific instruction?
So the specific instruction was that I had to go to the lawyers, to John Eisenberg, our senior counsel for the National Security Council, to basically say, you tell Eisenberg, Ambassador Bolton told me, that I am not part of this whatever drug deal that Mulvaney and Sondland are cooking up.
What did you understand him to mean by the drug deal that Mulvaney and Sondland were cooking up?
I took it to mean investigations for a meeting.
Did you go speak to the lawyers?
I certainly did.
You relayed everything that you just told us?
I relayed it precisely, and then more the details of how the meeting had unfolded as well, which I gave a full description of this in my October 14 deposition.
There was something wrong going on here, and White House officials were told repeatedly, go tell the lawyers about it. Dr. Hill, Lieutenant Colonel Vindman, Mr. Morrison, who reported to Mr. Eisenberg at least 2 conversations. We need the notes of those documents to find out what was said And again, attorney-client privilege cannot shield information about misconduct from the impeachment trial of the President of the United States. Now, it's interesting. This amendment is supported by 200 years of precedent. It's needed to prevent the President from continuing to hide the evidence, and that's why the specific documents requested are so important for this case. It's faithful to the Constitution's provision that the Senate shall have the sole power to try all impeachments. The final point I'll make today concerns urgency. The Senate should act on this subpoena now, at the outset of the trial. In 14 of the Senate's 15 full impeachment trials, threshold evidentiary matters, including the timing, nature, and scope of witness testimony and the gathering of all relevant documents, were addressed at the very outset of the trial. There are practical considerations as why the subpoenas need to be issued now. Resolving whether a subpoena should issue now would let us immediately engage with the White House to resolve asserted legitimate privilege issues, if any exist, and ensure you get the documents as soon as possible so they can be presented to the senators in advance of witness testimony. Waiting to resolve these threshold matters until after the parties have presented their case would undercut the process of a genuine, credible trial. Thus, common sense, tradition, and fairness all compel that the amendment should be adopted, and it should be adopted now. Members of the Senate, for all the reasons I've walked through today, I urge you to support the amendment to issue a subpoena for White House documents that are directly relevant to evaluating the President's scheme. The House did its job. In the face of the President's obstruction and categorical commitment to hide the evidence, we still gathered direct evidence of his conduct and determined that his conduct required impeachment. The President complains about due process in the House investigation, but he was not only permitted to participate, he was actually required to participate, yet he refused to do investigation. But he was not only permitted to participate, he was actually required to participate, yet he refused to do so. He refused to provide witnesses and documents that would tell his side of the story. So now it's up to you. With the backing of a subpoena authorized by the Chief Justice of the United States, you can end President Trump's obstruction. If the Senate fails to take this step, if it won't even ask for this evidence, this trial and your verdict will be questioned. Congress and the American people deserve the full truth. There is no plausible reason why anyone wouldn't want to hear all of the available evidence about the President's conduct. It's up to this body to make sure that happens. It's up to you to decide whether the Senate will affirm its sole power and constitutional duty to try impeachments, whether and when it will get the evidence that it needs to render a fair verdict. Don't surrender to the President's stonewalling. It will allow the President to be above the law and deprive the American people of truth in the process. A fair trial is essential in every way. Important for the President, who hopes to be exonerated, not merely acquitted, by a trial seen as unfair. Important for the Senate, whose vital role is to continue to protect and defend the Constitution of the United States, which has preserved our American liberty for centuries. And finally, important for the American people who expect a quest for truth, fairness, and justice. History is watching, and the House managers urge that you support the amendment, and I reserve the balance of my time.
Mr. Cipollone.
Thank you, Mr. Chief Justice, Majority Leader McConnell, Democratic Leader Schumer, Senators. It's remarkable that after taking the action of the breathtaking gravity of voting to impeach the duly elected President of the United States, And after saying for weeks that they had overwhelming evidence to support their case, the first thing that the House managers have done upon arriving finally in this chamber after waiting for 33 days is to say, well, actually, we need more evidence. We're not ready to present our case. We need to have subpoenas and we need to do more discovery because we don't have the evidence we need to support our case. This is stunning. It's a stunning admission of the inadequate and broken process that the House Democrats ran in this impeachment inquiry that failed to compile a record to support their charges. It's stunning that they don't have the evidence they need to present their case and that they don't really have a case. If a litigant showed up in any court in this country on the day of trial and said to the judge, actually, Your Honor, we're not ready to go. We need more discovery. We need to do some more subpoenas. We need to do some more work. They'd be thrown out of court and the lawyers would probably be sanctioned. This is not the sort of proceeding that this body should condone. Now, we've just heard that this is so important. Let's consider what's really at issue in the resolution here and the amendment.
Yeah, it does give me a hard time.
It's a matter of timing. It's a matter of when this body will consider whether there should be witnesses or subpoenas for documents. Why is it that the managers, the House managers, are so afraid to have to present their case, remember, they've had weeks of a process that they entirely controlled. They had 17 witnesses who testified first in secret and then in public. They've compiled a record with thousands of pages of reports.
Yes, definitely give me a hard time.
And they're apparently afraid to just make a presentation based on the record that they compiled and then have you decide whether there's any there, whether there's anything worth trying to talk to more witnesses about. Why is it that they can't wait a few days to make their presentation on everything they've been preparing for weeks and then have that issue considered? Because they don't think that there is any there, and they want to ram this through now. And they want to ram this through now when it's something that they themselves failed to do. So I want to unpack a couple of the aspects of what they're asking this body to do. Part of it relates to the broken process in the House and how that process was inadequate and invalid and compiled an inadequate record. And part of it has to do with what accepting their request to have this body do their job for them would do to this institution going forward, and how it would alter forever the relationship between the House and the Senate in impeachment proceedings. So first, as to the process in the House, what they're asking, the House manager asking this body to do now is really to do their job for them, because they didn't take the measures to pursue these documents in the House proceedings. And there have been a number of statements made about they tried to get the documents and no executive privilege was asserted and things like that. Let's look at what actually happened. They issued a subpoena to the White House. And the White House explained, and we were told a few minutes ago that the White House provided no response, it provided no rationale. That's not true. In a letter of October 18th, White House counsel Pat Cipollone explained in 3 pages of legal argument why that subpoena was invalid. And that subpoena was invalid because it was issued without authorization. We've heard a lot today about how the Constitution assigns the sole power of impeachment to the House. That's right. That's what Article 1, Section 2 says. It assigns the sole power of impeachment to the House, not to any member of the House. And no committee of the House can exercise that authority to issue subpoenas until it's been delegated that authority by a vote of the House. There was no vote from the House. Instead, Speaker Pelosi held a press conference, and she purported by holding a press conference on September 24th to delegate the authority of the House to Manager Schiff and several other committees and have them issue subpoenas. All of those subpoenas were invalid. And that was explained to the House, to Manager Schiff and the other chairman of those committees at the time in that October 18th letter. Did the House take any steps to remedy that? Did they try to dispute that? Did they go to court? Did they do anything to resolve that problem? No. Because as we know, all that they wanted to do was issue a subpoena and move on. They just wanted to get through the impeachment process as quick as possible and get it done before Christmas. That was their goal. So those subpoenas were unauthorized. Now, what about some of the other things that they brought up? The witnesses. Witnesses who were directed not to testify. And part on this, we've heard Manager Schiff say several times that the White House never asserted executive privilege. Well, let me be clear on that. That's a lawyer's trick, because it is technically true that the White House didn't assert executive privilege, because there's a particular situation in which you do that in a particular way that you do that. But there's another doctrine of immunity of senior advisors to the president that is based on the same principles as executive privilege, and that has been asserted by presidents of both political parties since the 1970s at least. So that's, and this is what one attorney general explained about that. Quote, "The immunity such advisors enjoy from testimonial compulsion by a congressional committee is absolute and may not be overborne by competing congressional interests," end quote. That was Attorney General Janet Reno in the Clinton administration, explaining that senior advisors to the president are immune from congressional compulsion. And that doctrine, that immunity, is rooted in the same principles of executive privilege. It's been asserted by all presidents since the 1970s, and that was the basis on which a number of the advisors whose pictures they put up were directed not to testify. Did they try to challenge that in court? Did they go to court on that one? Did they try to go through the constitutionally mandated accommodations process to see if there was a way to come up with some aspect of testimony that could be provided? No, none of that. They just wanted to forge ahead, rush through the process, not have the evidence, and then use that as another charge in their charging sheet for the impeachment, calling it obstruction of Congress. And what that is Professor Turley explained, this idea that when there's a conflict between the executive branch and the House and seeking information, and the president is asserting constitutionally based privileges, that's part of the operation of separation of powers. That is the president's constitutional duty to defend the prerogatives of the office for the future occupants of that office. And it is not something that can be charged as an impeachable offense, as the House Democrats have tried to say here. To do that is an abuse of power. That's what Professor Turley explained. It's Congress's, it's the House Democrats' abuse of power. We just heard Manager Lofgren refer to executive privilege as a distraction. She was asserting that these issues of executive privilege are just a distraction that shouldn't hold things up. But this is what the Supreme Court has said about executive privilege in Nixon versus United States, that the protections for confidentiality and executive privilege are, quote, fundamental to the operations of government and inextricably rooted in the separation of powers under the Constitution, end quote. Inextricably rooted in the separation of powers. That's why it's the president's duty to defend executive branch confidentiality interests, and that is what the president was doing here. Now, the process that they pursued in the House abandoned any effort beyond issuing the first subpoena that was invalid to work out an accommodation with the White House, and instead just tried to rush ahead to have the impeachment done by Christmas. What does that lead to now? They're coming to this body
I got nothing on
after a
this
process that was half-baked, that didn't compile a record sufficient to support their charges, and asking this body to do their job for them. Now, as Leader McConnell pointed out in some comments earlier today, to allow that, to accept the idea that the House can bring an impeachment here that is not adequately supported, that has not been investigated, that has not got a record to support it, and to turn this body into the investigatory body would permanently alter the relationship between the House and the Senate in impeachment proceedings. It's not the role of the Senate to have to do the House's job for them. It's not the role of the Senate to be doing an investigation and to be doing discovery in a matter like the impeachment of a president of the United States. If the House has not done the investigation and cannot support its case, it's not the time once it arrives here to start doing all that work. That's something that's the House's role. So, this is something that is important for this institution, I believe, not to allow the House to turn it into a situation where this body would have to be doing the House's work for it. If there is not evidence to support the case, if they haven't done their investigation, then they're not going to be able to support their case. Again, what's at issue here, and I think it's important to recall on the issue of this amendment, it's not whether the Senate, whether this body will be considering whether there should be witnesses or not, but when that should be considered. And there is no reason not to take the approach that was done in the Clinton impeachment. 100 senators agreed then that it made sense to hear from both sides before making a determination on that, to hear from both sides, to see what sort of case the House could present and the president's defense. And that makes sense. In every trial system, there is a mechanism for determining whether the parties have actually presented a triable issue, whether there is really some there that requires the further proceedings. And this body should take that common sense approach and hear what it is that the House managers have to say. Why are they afraid to present their case? They had weeks in a process that they controlled to compile their record, and they should be able to make that presentation now. And the one point that I will close on, we've heard Manager Schiff say several times that we have to have a fair process here, and I was struck by it that at one point he said if you allow only one side to present evidence, the outcome will be predetermined. The outcome will be predetermined. That's exactly what happened in the House. Let's recall that the process they had in the House was one-sided. They locked the president and his lawyers out. There was no due process for the president. They started with secret hearings in the basement. The president couldn't be present by his counsel. He couldn't present evidence. He couldn't cross-examine witnesses. And then there was a second round in public, where again they locked the president out. And we've heard, they just said that the president had an opportunity to participate. In the third round of hearings that they held before the Judiciary Committee, after one hearing on December 4th, Speaker Pelosi, on the morning of December 5th, went out and announced the conclusion of the Judiciary Committee proceedings. She announced that she was directing Chairman Nadler to draft articles of impeachment. That was before the day that they had set for the president even to tell them what rights he wanted to have and to exercise in their proceedings. It was all already predetermined. The outcome had been predetermined. The Judiciary Committee had already decided it was not going to have any fact hearings. There was no process for the president. He was never allowed to participate. So when Chairman Schiff says here that if you only allow one side to present evidence, that predetermines the outcome, that's what they did in the House, because they had a predetermined outcome there, because it was all one-sided. And for him to lecture this body now on what a fair process would be takes some gall. A fair process would be when you come to the day of trial, be ready to start the trial and present your case, not ask for more discovery. The president is ready to proceed, and the House managers should be ready to proceed, and this amendment should be rejected. Thank you.
Counsel, the House managers have 8 minutes remaining.
The House is certainly not asking the Senate to do the House's job. We're asking the Senate to do its job, to hold a trial. Have you ever heard of a trial that doesn't have evidence, that doesn't have witnesses? That's what this amendment is all about. Just a moment about the subpoenas. President Trump, refused to provide any information to the House, ordered all of his people to stonewall us. Now, it's been suggested that we should spend 2 or 3 years litigating that question. I was a young law student, actually, working on the Nixon impeachment many years ago. And I remember the day that the Supreme Court issued its unanimous decision
what is the
that
one
the
condition for
president
Baba is you?
had to release the tapes. I think U.S. v. Nixon still governs the president. The House and the Senate should not be required to litigate U.S. v. Nixon back to the Supreme Court and down again for it to be good law. It is good law. The president has not complied with those requirements to the detriment of the truth. This isn't about helping the House. This isn't about helping the Senate. This is about getting to the truth and making sure that impartial justice is done and that the American people are satisfied that a fair trial has been held. I would yield now to my colleague, Mr. Schiff.
Mr. Philbin says that the House is not ready to present its case. Of course, that's not something you heard from any of the managers. We are ready. The House calls John Bolton. The House calls John Bolton. The House calls Mick Mulvaney. Let's get this trial started, shall we? We are ready to present our case. We are ready to call our witnesses. The question is, will you let us? That is the question before us. Now, Mr. Philbin says, well, if I showed up in court and said I wasn't ready, the judge would throw me out of the court. Of course, we're not saying we're not ready. But you know what would happen if Mr. Philbin went into a court and the judge said, I've made a deal with the defendant. I'm not going to let the prosecutor call any witnesses. I'm not going to let the prosecutor present any documents. You know who'd get thrown out of the court? The judge. The judge would be taken out in handcuffs. So let's step out of this body for a moment and imagine what a real trial would look like. It would begin with the government receiving documents, being able to introduce documents, being able to call witnesses. This trial should be no different. Now, Mr. Philbin makes reference to the Cipollone letter on October 18th, which followed a Cipollone 8-page letter on October 8th saying, we're not going to do anything you ask. Part law, part diatribe, mostly diatribe. You should read it. It's a letter basically that says
I don't think they can
what
do
the president
a
said on
secret
that TV
ballot
screen,
because
which
there's a
is
provision
we're
in
going
the
to fight all
Constitution that
subpoenas.
says, I believe, that 20%
The doctrine of absolute immunity that counsel refers to has, yes, it has been invoked or at least attempted by presidents of both parties and rejected uniformly by the courts, including in the most recent decision involving Don McGahn, the president's former White House counsel, where the court said that would make him a king.
Any question pending.
He's no king.
Can force an open vote, so.
And this trial has determined that he shall not become a king, accountable to no one, answerable to no one. And what's more, this idea of absolute immunity, this fever dream of presidents of both parties, it has no application to documents. Again, this amendment is on documents. There's no absolute immunity from providing documents. And as Representative Lofgren illustrated, when this case has gone to the Supreme Court, in the Nixon case, the court held that the interest in confidentiality in an impeachment proceeding must give way to the interests of the truth and the Senate and the American people. You cannot invoke privilege to protect wrongdoing. You cannot invoke privilege to protect evidence of a constitutional crime like we have here. And finally, with respect to those secret hearings that counsel keeps referring to, those secret depositions in the House were so secret that only 100 members of Congress were able to be there and participate. Only 100. That's how secret that chamber was. Imagine that in the grand jury proceedings in the Clinton investigation or in the Jaworski, the Nixon investigation, imagine inviting 50 or 100 members of Congress to sit in on those. Imagine, as the president would like here, apparently the president insisting on having his lawyer in the grand jury because there was a case being investigated against him. Now, we had no grand jury here. Why is that? Why did we have no grand jury here? Why was there no special prosecutor here? Because the Justice Department said they're not going to look into this. Bill Barr's Justice Department said there's nothing to see here. If it were up to that Justice Department, you wouldn't know anything about this. That's why there was no grand jury. That's why we in the House had to do the investigative work ourselves. And yes, just like in the Nixon case, just like in the Clinton case, we used depositions. And you know what deposition rules we used? Those terribly unfair deposition rules we used? They were written by the Republicans. We used the same rules that the GOP House members used. That's how terribly unfair they were. My gosh, they used our rules. How dare they? How dare they? And now why did we do depositions? Because we didn't want one witness to hear what another witness was saying so they could either tailor their stories or know that they just had to admit so much and no more. It's how every credible investigation works. And this, the counsel can repeat all they like that the president didn't have a chance to participate, didn't have a chance to have counsel present in the Judiciary Committee or to offer evidence. They can say as much as they like. It doesn't make it any more true when they make the same false representation time and time again. It just makes it that much more deliberate and onerous. The president could have presented evidence in the Judiciary Committee. He chose not to. And there's a reason for that. There's a reason why the witnesses they've talked about aren't material witnesses. They don't go to the question of whether the president withheld the aid for this corrupt purpose. They don't go to any of that because they have no witnesses to absolve the president on the facts. You should want to see these documents. You should want to see them. You should want to know what these private emails and text messages have to say. If you're going to make a decision about the president's guilt or innocence, if you're going to make a decision about whether he should be removed from office, you should want to see what these documents say. Now, if you don't care, if you've made up your mind that he's the president of my party or for whatever reason, I'm not interested. And what's more, I don't really want the country to see this. Well, that's a wholly different matter. But that's not what your oath requires. It's not what your oath requires. The oath requires you to do impartial justice, which means to see the evidence. To see the evidence. That's all.
That wasn't too bad, was it?
Just don't blind yourself to the evidence.
That was an easy one.
It's just
the last one. We got that one pretty fast. That was a pretty easy one.
The majority leader is recognized.
I send a motion to the desk to table the amendment and ask for the ayes and nays.
The question is on the motion to table. Is there sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. No. Mr. Barrasso. Aye. Mr. Bennett. No. Mrs. Blackburn. Mr. Blumenthal. No. Mr. Blunt. Aye. Mr. Booker. No. Mr. Bozeman. Aye. Mr. Braun. Aye. Mr. Brown. Aye. Mr. Burr. Aye. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth, Mr. Durbin, Mr. Inze, Ms. Ernst, Mrs. Feinstein, Mrs. Fisher, Mr. Gardner, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Ms. Harris, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Ms. Hirono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Inhofe, Mr. Johnson, Mr. Jones, Mr. Kane, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Lankford, Mr. Leahy, Mr. Lee, Mrs. Loeffler, Mr. Manchin, Mr. Markey, Mr. McConnell, Ms. McSally, Mr. Menendez, Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Paul, Mr. Perdue, Mr. Peters, Mr. Portman,
All the ayes.
Mr. Reed.
What are this? 48 ayes, 52 no.
Mr. Risch,
That'll be my bet.
Mr. Roberts, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Mr. Shelby, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey,
48 yes, 52 no.
Mr. Udall, Mr. Van Hollen, Mr. Warner,
Or 52 yes, 48 no. Sorry, it's motion to
Ms.
table.
Warren,
He's right. 58.
Mr.
52
Whitehouse.
48 no. Sorry.
Mr. Wicker, Mr. Wyden, Mr. Young,
Are there any senators in the chamber wishing to vote or change his or her vote?
Democrat switch.
If not, the yeas are 53, the nays are 47. The amendment is tabled.
Is there 53 members of the House that are 53 members of the Senate that are Republican, not 52?
Mr.
Then
The Democratic
my
leader is
mental count was
recognized.
wrong.
Mr. Chief Justice, I send an amendment to the desk to subpoena certain documents and records from the State Department, and I ask that it be read.
The clerk will read the amendment.
Okay, so now we're just going to do this over and over again with different subpoenas for different things. So just rinse, repeat, rinse, repeat. I'm going to kill the stream and get a little bit of food. But
The
thank you
senator
for
from
joining
New
me
York,
for
Mr.
this
Schumer,
impromptu
proposes an
impeachment
amendment
coverage.
number 1285.
As always, if you've not already done so, if you
At the
could
appropriate
please
place
like
in the resolving
stream,
clause,
I
insert the
would
following
appreciate it.
section.
And if you've
Notwithstanding
not already done so,
any
check
other
out the
provision
video
of this
from earlier today,
resolution
which is a lot of
pursuant to
fun.
Rules 5 and 6
I
of
may
the
not
Rules
keep
of
this
Procedures and Practice
public. I may make
in the
this
Senate when
unlisted.
sitting in impeachment trials,
Kind of not the
1. The
best
Chief
quality
Justice
thing
of the
I've ever
United
done in my life,
States,
so I
through
may
the
make this
Secretary of the
unlisted.
Senate,
Just
shall
for those
issue a
who
subpoena to the
join me
Secretary of
while we're
Senate
here.
commanding him to
Just
produce
FYI.
for the time period from
And,
January
yeah,
1,
it's just gonna be the same thing
2019
over
to
and
the
over and
present.
over again.
All documents, communications, and other records within the possession,
just the same
custody,
thing.
or control of the Department of State,
Till later, my friends. Hope you're
referring
well.
or relating to A,
Bye.
all meetings and calls between President Trump and the President of